wake up, so I was freaking out there for a minute. Sorry.
Okay, they're getting it ready now. So,
Mr. Chair, we're actually on the air whenever you're ready to begin.
Okay, great. Thank you, Mr. Villalobos. Good morning. Welcome to the June 2nd hearing of Santa Barbara County Planning Commission. Please join me in the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, and Mr. Villalobos can use, let me shut this off. Jeez. Can you start us out, please, with items 2 and 3 on today's agenda?
Yes, thank you, Mr. Chair, and good morning to the Commission. Planning Commission hearings are televised live on County Santa Barbara Television's CSB TV Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, Santa Maria, and Orchid areas. Rebroadcasts of Planning Commission hearings are on Fridays after 5 p.m. on CSB TV Channel 20. Today's hearing will also be streamed live on the county's website and will be available for download in a day or two. Moving on to the roll call, Commissioner Cooney.
Here.
Commissioner Bradley.
Here.
Commissioner Park.
Present.
Commissioner Blau.
Here.
And Chair Freeney.
Here.
Thank you.
Okay, thank you. Good morning, Mr. Wilson. Can you move on to items 4 and 5, please?
Good morning, Chair and members of the Commission. In regards to the status of the agenda today, we had 3 items scheduled for the standard agenda. However, there is a request for a continuance on the first item, which is the appeal of the G&K Cannabis Processing Building. That request was for continuance to June 9th. And then we have the 2 other items, Ramey recorded map modification that was continued to today's date, as well as the appeal of Sun Valley Ranch was also continued to today's date. Staff is ready and prepared to present on items 2 and 3. And my understanding is that we also support the request for continuance as well to June 9th. So that concludes the status of the agenda, and I can move on to the projection report, Mr. Chair.
Okay, thank you.
Our next scheduled hearing is June 9th. We have 4 items projected for that date. We continue the appeal of the Hacienda Amador homestay application to that date, as well as the Summerland Elementary School is on that date. And then today we'll take action on the request to continue G&K to that date. And then we have the Santa Rita Holdings Cannabis Cultivation Project on June 9th. Then following that, our next scheduled hearing is on June 30th, and we have the continuance of the neighborhoods of Willow Creek or Keyside 21 on that date, as well as an appeal of Roadside Blooms Mixed Light Cannabis Cultivation application on June 30th. And then next hearing after that is July 7th. We have a Cresco Cannabis Cultivation and Processing scheduled for that date. And then nothing on July 14th at this date. And then July 28th, we have Far Western Liquors and PR Investments, the appeal of the Orchid Gas Station on July 28th. August 4th, at our last hearing, we continued New Era to that date. And then there isn't anything projected until we get to the Exxon hearings, which is set for September 8th and September 10th. So that concludes the projection report. And I just wanted to, while we're on this topic, report back to the Planning Commission on a couple items that I'm working on to get on calendar. One of is a briefing a briefing with the CEO's office in the Business License Division. At the last couple of hearings, there's been a request for the Commission to have a representative from the business license attend and provide a briefing. And our conversations this week is we're looking at a couple dates, June 30th and or July 14th. July 14th, that would be depending on if we have any other items on that date so we can be efficient with our time and money. But I will when we get that date confirmed, I'll report back to the Commission on those dates. I'm actually also trying to project another potential workshop. Coordination on that would be pallet housing just to give a briefing to the Planning Commission on the trends of that and regulations, but that may be later this summer, early fall, before I get that scheduled due to research and coordination efforts on that. That concludes the projection report at this time. And I think Director Plowman will brief you as far as COVID-19 and our hearing formats as we go forward.
Okay, thank you, Mr. Wilson. Any questions? Oh, there we are. Commissioner Park?
Yes, I appreciate your report, Secretary Wilson, and I especially like the idea of having someone brief us on the business licensing issue on cannabis. I think that'd be a very healthy thing to happen. I want to suggest something else as well. As I'm sure many of us know, we have a decision by Superior Court Judge Anderle in the writ of mandamus case in the Busy Bee matter. And I'm a little concerned that some people won't be aware of it and what it means, and other people will overreact to it and think it means a lot more than it does mean. And I think it would be beneficial to have some sort of a briefing on that decision and its consequences for us at some point in time and relatively soon. I mean, I could do it, but I think it's better to come from county council or P&D staff. We will touch on it today because it's referred to in the arguments for the matter that'll be before us. But we should probably hear what we hear today and then decide whether there's something more that we should do. So I'd like you to consider that request.
Okay.
I'm sorry. So, Mr. Chair and Commissioner Park, I did provide a briefing on it last week. I'm happy to repeat what I said last week in the director's report, and then Ms. Richardson could add something, but I don't know that a separate item on it is necessary, but why don't we share what we have today, and then we can talk about it further if necessary.
Okay. When would you like to, you want to go over that again then, Director Plowman, at a certain time?
I'll do it in my director's report.
Okay.
And then Ms.
all right.
Richardson can add what she would like.
Okay, Commissioner Park? Is that going to work for now, and then we'll go from there?
Well, I think so. And I think we will also learn more about it just in the discussions on the Sun Valley project today as well. So just kind of depending on what everybody hears and their understanding, that might determine whether we need any additional briefing.
Okay, great. Commissioner Bridley?
I totally concur that I would like to hear that again, Director Plowman, and so thank Commissioner Park for bringing that up. I actually had a conversation with the Ag Advisory Commission for the 2nd District, Ron Caird, and I recall that last year we had had a briefing from the Ag Commissioner's office, because the reason Mr. Caird called me was that their agenda is full of a lot of these LUP appeals, and he's saying, there's not much that they're having to opine on. And anyway, I thought it might be time for a quick touch from the Ag Commissioner's office in some way, just because we overlap on the cannabis cases, and especially after the Anderle decision, maybe this is the time to have another, update from the Ag Commissioner's office, or a briefing from you, Commissioner Director Plowman, or something about how the Ag Advisory Commission is reviewing the LUP appeals, the DP, the CUPs, and cannabis. Anyway, just an update, because last year I thought it was very helpful to hear from the Ag Commissioner's office on that. I actually went to a couple of their meetings. I haven't done that lately. So very interested also in our farming commissioners to see if that seems like a good use of, I'm thinking not more than an hour, a half hour. What do people think?
I think it's a good idea. If we get the other agencies to help us on what they know and what they're thinking. So that's a great idea, Commissioner Bridley.
So maybe whenever there's a light agenda, Mr. Wilson, Ms. Plowing can look at that. I don't know. Anyway, that's my request. Thank you.
Okay, thank you. Commissioner Blau?
Yeah, I was also, this is the first time I remember in a long time I've actually read a court decision from first word to the last word, and all the notes at the bottom as well. And I had a couple questions both for Ms. Richardson and perhaps for Commissioner Cooney and for Commissioner Park, in that this was a great coup for Mike Grisoni. I mean, he basically won 7 out of 7 arguments, and it was very clear to me from the judge's discussion that the county has done a marvelous job of complying with the law, and in every sense of it, he's to be congratulated. So is the entire department, I think. My one concern is I do know that court cases, unless they're certified, decertified, and I don't know about this. I need help from Commissioner Cooney and Commissioner Park, but can we now use this case going forward as kind of a benchmark for making future decisions, or is there some other certification or parts of it that could be disputed? And because to me, it was interesting reading. It was the first time I read one that I really enjoyed it. And I was like, okay, this is a nice map going forward to making decisions so that we lessen the number of appeals that are going forward. So that's kind of a question from my 2 fellow commissioners and for Ms. Richardson.
Okay, Ms. Richardson, good morning.
Ms. Richardson, I can't hear you.
We're not hearing you, yeah. You show you're unmuted, but we don't have audio.
Try a different microphone.
Jenna, also, you might try leaving the meeting and rejoining. That might help as well.
Okay.
Chair Freeney, on this topic, I recommend that we maybe move through the agenda to director's report and then maybe have a discussion. We're not agendized for deep discussion on this, but Director Palma is going to mention it during her director's report, and then we could probably have some questions at that point.
Fair enough. Okay, so we'd like to move on with this topic. All of my fellow commissioners have their hands up, so if it's a new topic, if not, we'll move on. So Commissioner Bridley, your hand is still up.
Oh, I'm sorry, Mark, my fault.
Commissioner Park.
I wanted to actually not talk about Judge Anderley's decision. I think we'll talk about that later, and we can readily deal with Commissioner Blau's question at that time. But with respect to the suggestion by Commissioner Bridley about reserving some time to speak to representatives from the Ag Advisory Committee, I think that's a very good idea. And I'm not sure, frankly, Commissioner Bridley, if you were talking about the Ag Commissioner or the committee, they're obviously different things. But the committee, when you look at their agenda, they get all these land use cases in front of them, yet they have no really jurisdiction or authority to do anything about them. They kind of weigh in and so forth. And it's a strange process because it's not noticed the same way ours are. So there'll be very one-sided hearings in terms of the applicant will present and there's no opposition and things like that. So I think if we had some discussion as to roles and so forth, it would be beneficial to them and give them more time to deal with ag policy issues instead of just hearing one land use case after another. I am appearing for a presentation in front of the AAC tomorrow, and I can bring that up. And also I've been having some conversations with Paul Van Leer, the chair. Okay, thank you.
Okay, Ms. Richardson.
Audio again, Chair.
Now we have audio.
Okay, great, thanks. So we can talk briefly about Busy Bee and the director's report. And I'll
Can you speak a little louder, please?
Sure. I'll talk briefly about Busy Bee during the director's report, but in terms of APAC, I just wanted to clarify that their role is defined by our zoning ordinance and our statute. So we can have, and I can work with planning to set up a briefing, but the commission does not really have a role to sort of direct what their review should or could look like.
Oh, okay. I think we're just interested in getting together and having an open discussion. So however you would like to guide that, that would be great.
But
Commissioner
we also
Parker?
weren't referring to APAC. We weren't referring to APAC. The comment was the Ag Advisory Committee, not APAC. Very, very different.
Yes, I'm aware of that. No, I was talking about the Ag Advisory Commission. I actually suggested that it be the commissioner herself.
I know you were.
And so, I would actually leave it in the trustworthy hands of Lisa and Jeff to figure out what is the best way. But just having them present for a half-hour discussion would be great at this point.
So that would be the county ag commissioner is who you're speaking of, Commissioner Bradley?
Right. And last year, I think we also had the chairman that I know Commissioner Park may speak to in his other matters. So if the commissioner, chair wants to attend, that's great. Very flexible, not urgent, just want to follow up.
Okay, great.
But anyway, none of us were referring to APAC, which is the Ag Preserve Advisory Committee. So that's what Ms.
Correct.
Reed-
Very good.
Let's not get confused. Thank you.
Okay, let's move on to item 6, and that is public comment. Do we have anyone from the public who would like to speak this morning on items not on today's agenda?
Mr. Chair, we didn't have anyone who signed up for items not on today's agenda. I know that we have a couple people who are in attendance, I think, for some of our items on our standard agenda. If you wanted to speak on general public comment, just raise your hand and I'll call on you. I'm not seeing any takers, Mr. Chair.
Okay, very good. We'll move on to item 7, which is Planning Commissioner's informational reports. I think we may have already covered all of that a little bit earlier.
By accident, sorry.
Okay. All right, and finally on to the item 8, the director's report. Director Plowman, good morning. And we have you muted. There we go.
Good morning, Mr. Chair, members of the commission. Just getting up my report here. So in terms of COVID-19, I don't have any new information. There was an expectation that OSHA would be reviewing its COVID-19 standards for the office and workplaces, and I have not received any updates on that. We are still working towards opening our offices on the 15th. Our plan is to open for appointments, both virtual and in-person appointments only, to sort of meter the number of people that are coming into the office. And we are working on, as I mentioned, potential changes to the Brown Act that would allow for some remote participation by commissioners. And I believe that the governor will not be lifting the provisions put into place in the Brown Act that allow for remote hearings and for a few months to give agencies some time to transition back to in-person hearings. So we will be working on that as well. And I will keep you posted on a schedule for that transition. So Busy Bee. I mentioned last week that Judge Anderle had upheld our decision and found that the county had conducted legally sufficient site-specific review of the project by using the PEIR and our checklist associated with that. In addition, they found that, or Judge Anderle found that our approval of the land use permit, or the commission and the boards, cured the alleged violation for the expansion of the non-conforming use. And I think what Mr. Gazzoni indicated to me and also to the board in a communication is that we can expect that this will sort of guide how future decisions will occur on these types of projects and in these particular cases. We don't know if that will mean less cases being filed, CEQA cases being filed, but or cases against county's process. But his expectation is that this really lays a roadmap for future decisions on cannabis cases, and there are some already in the process right now. I don't have much more to add than that. Let me just see if there's anything else I can indicate. So we have West Coast Farms and Castle Rock Family Farms that are in process right now over in the courts. So we'll see how this actually predicts outcomes in those particular cases. So, Ms. Richardson, do you have anything to add to that?
Sure, commissioners. I was just going to add, so since this isn't agendized, I would encourage that we not discuss it in detail. But sort of briefly, as Commissioner Blau alluded, this is not a Court of Appeal decision that would be binding on future litigation, but practically we could expect similar cases to also be in front of Judge Anderle and expect a similar decision for cases that have similar facts. We do have different cannabis projects, but I imagine we will discuss it in a little more detail as part of the Drum Canyon project that we have on today's agenda. But if the commission after that perhaps wants to ask more questions or get more into the decision, we can always agendize that for further discussion.
Okay, Commissioner Blau, you're muted.
That's kind of what I thought, as I remembered it had to be a Court of Appeals before it was a case you could rely upon. I didn't know the real answer. That's why I asked the question. But I do have to commend the county council, particularly Mr. Garzoni, because when I read the decision by the judge, it was a great kudos for Mr. Garzoni and the entire staff, and I thought that was important to say. I did have one other question. This is information only, but as a person who frequently has to sign the indemnity agreement for the county when it has to do with potential future litigation, so I'm just curious to know how the money works in this case. I understand that if I enter into an agreement to pay for a environmental review document and it's challenged by Mr. Chatillo or anybody else, and should I lose, I pay my attorney's fees, I pay the county's attorney's fees, and I pay Mr. Chatillo's fees. I just was curious what happens in this case what happened to the applicant when he won the case, or the county won the case. I don't care about the particular one, but give me the generic answer for that kind of a deal, just so I know going forward.
Sure, Commissioner Blau and commissioners. And just to say, it was a big win. Lena Somate in our office worked on it, and she worked very hard. In terms of indemnification, you're right, the applicant does indemnify the county. So the applicant, Busy Bee, did or was billed for our office's staff costs to file everything, so an hourly rate. And then generally in CEQA cases, if the county were unsuccessful, we would be responsible for the petitioner's attorney's fees. Generally, when we're successful, I don't believe the petitioner pays our attorney's fees. So Busy Bee, the applicant, did pay for their own attorney's time as well as the county's attorney's time.
So just as a matter of, by Don Quixote and the windmill, if there's any way that we can make arrangements to change that, would sure make me happy, because I think that's totally unfair and unreasonable. Maybe I need to go to London or England in order to get that corrected, but it just seems to be totally unreasonable that occurs that way. Just a comment.
Commissioner Blau and the rest of the commission, just to clarify, that comes from the Land Use and Development Code ordinance, so would require board action and ordinance amendment.
No, but then I will contact my supervisor and see if I can't nudge that along, because it sure would make sense to me.
Thank you, Commissioner Blau. Commissioner Park.
Two things. I just wanted to report that I've heard informally from basically all the participants, and all had considerable praise for the high quality work done by County Counsel's office and the briefing in this matter. So I think they're to be commended. Also, I think it is still important that we have some conversation about what it means and doesn't mean. Obviously, it's a very significant decision regarding the adequacy of the PEIR. But it still leaves it up to the Planning Commission to examine whether there are environmental impacts that are not covered in the PEIR when we look at individual cases. And it still leaves it open to us. In fact, we have a duty, of course, to apply the general plan if there are issues. So very significant in some important ways, but it doesn't preempt the field for our work. And if Ms. Richardson believes that we need to be agendized to talk about that further, then I can support that. Thank you.
Okay, Mr. Chitillo, stand by there. I'm trying to get something done here. Hang on.
So Mr. Farini, or
Yes.
Mr. Farini, Mr. Chair, I'm still in the middle of my director's report, so perhaps I can finish
I
that.
didn't know that. I thought you
Yes.
were being very brief today.
No,
Okay.
no.
Well, please continue.
Yes.
Thank you.
So I also wanted to report on, the board met yesterday to talk about ARPA funding, and then also had discussions about allocation of cannabis funding. And I think there were two important things that came out of that meeting that I heard, and I couldn't listen to the whole hearing, but the board has decided to allocate $2 million to the purchase of the San Marcos foothills. Apparently the public was able to raise, and maybe Mr. Chitillo during public comment can remark on this, was able to raise, I think, 17 million. And the board is going to add 2 million. And I think that closes the gap for the acquisition of the foothills. So the project that was approved, I don't know, maybe 15, 20 years ago, will not be developed. I think it was 14 lots up on the San Marcos foothills. So this additional acreage will be added to the 200-acre easement that was provided by the previous owner of the property, and then also the county park that I believe is around 9 acres up there. So that's a real accomplishment, I think, for the community to be able to pull together and raise that kind of money in a very short period of time. And then this is one way in which the cannabis tax dollars can be used for community benefit. And then also there was, I believe, about $100,000 that are going to be allocated to some recreational efforts in Guadalupe, along the Guadalupe Dunes, that will help provide seed money for additional grant funding. So those are the two things I wanted to report on from the board yesterday. There was a lot of discussion about ARPA, and I'm sure there'll be more information to follow on that and how that funding will be allocated. And I believe there's about 2 or 3 years which the county has to spend that ARPA funding. And then just to keep you apprised of what's going to be coming up at the board, the changes to our building code, where we're adding the appendix for emergency housing, is the first readings on the 15th of June. Our SFS Farms appeal by Melville is on the 22nd. And then the Suarez appeal, which was in Cuyama, is on the 13th of July. And we will also be going back, as I mentioned previously, to the board on the utility grade solar ordinance to make sure the scope of work is correct before we begin environmental review on that, and work in earnest on totally fleshing out the components of the ordinance, and that's also on the 13th. We have the other upcoming appeals that have not been scheduled yet for a particular day, but Canarios, Autumn Brands, and Central Coast Ag land use permit. So those will be in process, and I'll let you know as soon as we have a date for docketing. And I'm happy to answer your questions.
Okay, thank you. Commissioner Cooney?
Yes, thank you, Mr. Chair. For Ms. Plowman, back to your first item, I was kind of expecting, though I was out of town and out of touch, that the county would be moving to the least restrictive tier of COVID protection as of yesterday, but that didn't happen. Ventura County apparently did. move to the yellow tier. But do you know what is holding up Santa Barbara County?
Mr. Chair, Commissioner Cooney, I thought it was the case rates, but I'd have to go back and look at the information that's sent over by the director of the department, Dr. De Reynoso. But there has been communication among the directors in the departments about the fact that she was uncertain as to whether or not we would ever actually make it to the yellow tier before June 15th. So I'd have to go back and look at the data, but there was one particular aspect of the way they count the data that was holding us back.
Thank you.
Yeah.
Commissioner Bradley.
Director Plowman, getting back to the land use implications on the COVID condition, we had all those emergency ordinances that allowed people to use parking lots and right-of-ways and things for businesses during COVID. Is there thinking by your department that that's going to revert on June 15th or whenever we get to the yellow tier, or how? I thought that the ordinance was a little vague, just saying, and until the pandemic ends or something. So I'm wondering, how do you go back to whoever was given land use permits for changing their operations to have some limited business outside? How does that get pulled back into the barn, so to speak?
So, Mr. Chair, Commissioner Bradley, we did not issue permits for that.
Oh,
We
okay.
did not. So we waived the requirement for any of that. And what will happen is those amendments will be in effect until the county declares that the state of emergency is over. Times the state of emergency stays in place for a period of time because of funding streams that are associated with that state of emergency. So like during the when we had the debris flow and whatnot, that state of emergency was extended for a period of time because of FEMA funding. So I don't have a date when the board will actually declare that the state of emergency is over, but once the board does that, then that emergency ordinance will be null and void.
Okay.
But the Public Works Department previously had and will remain, it will remain as a dining in the right of way program.
Which they already have.
They already have,
Available.
they had it before the pandemic and they will maintain that. And so people can work with Public Works to get a permit to be able to have dining in the right of way. So probably on the sidewalks is what we're looking at.
Okay. Huh, interesting. Okay. Well, hopefully there's no many places in the rest of the county like the Funk Zone downtown, because that is pretty darn crazy with everybody in whatever parking areas they had and in the right of way. I'm like, well, there is no car in the Funk Zone. So last time I was in Los Alamos, it was still charming. So thank you.
Commissioner Blau, unmute.
Along those lines, there's several restaurants in northern Santa Barbara County that did a lot of expensive remodeling to provide outdoor seating. And quite frankly, it was a huge improvement to their restaurant. I mean, I gather they can't get there when it's cold and nasty, but when the weather's nice, we're all going like, want to be indoors? No, we don't want to be indoors. We want to be on the patio with the heaters and the little tent things and so forth. So I would hope that the staff would, when they take this back to the board, let's not look at this as one shoe fits all. There are, and I get it, there's issues with parking, and although in Orchid and Los Alamos and Los Olivos, we've ignored that entirely. But I'm just saying, for some restaurants, the outdoor dining has been a huge benefit to them and a huge benefit to the patrons. I just say that for staff to Ms. Plowman, if you could kind of keep that in mind as we go forward. I mean, I'll give you the best example is Uliveros. It's a far better restaurant today than it was a year ago. Much more comfortable, much more friendly. I'm hoping, given his use of the bar unrestricted, he would make more money, pay more taxes. It's a benefit to everybody. It's just my comment.
Yeah, and Commissioner Blau, through the chair, I have spoken to the Public Works Director about whether or not they would be expanding their right-of-way program to include, because I'm not sure about the particular restaurant you're talking about, whether they are actually in a parking space out in front of their building or whether they're just on the sidewalk. But that's something that could be discussed with the Public Works Director about whether or not they want to allow the use of some of those on-street parking spaces.
Yeah, in their case, it's mostly in their let's call it their patio area or sidewalk. It's just that they have more seating than was originally approved for the project, but it has worked out marvelously for everybody, especially as patrons. That's the important part.
I think we've been seeing that all over the county, and I mean, if you look at State Street and anywhere you go, actually across the country, this type of thing happened, except where weather prohibited it. And it'll be, I think all jurisdictions are trying to figure out how to transition away from a pandemic, but maybe allowing some of the things that had happened during the pandemic, because they did help. They're going to help businesses recover. And we are talking with board members about certain elements and how we might be able to incorporate those elements of our urgency ordinance and how we could incorporate those into our code in the future.
Okay, thank you. Director Plowman, is that?
That concludes my report.
Okay, very good. Okay, we're going to open up a public comment on the administrative agenda. So if there are members of the public who would like to speak on items that we've covered today, please let Mr. Villalobos know. Now, Mr. Shatillo, it appears you have some public comment.
I do. I wanted to thank you, Mr. Chair and members of the commission. I wanted to respond to Director Plowman's planning report on two topics. First of all, with respect to the San Marcos Foothills preservation effort, Ms. Plowman was incorrect that the campaign was complete. But it is, we are getting much closer, and we very much appreciate the county's determination, the board's allocation of funds. The campaign is in two phases. And the first phase is to purchase the property. And for that, we've arranged financing in addition to the funds that have been collected from the community, and including pledges that have not yet been paid. So there is a continuing need for fundraising in order both to meet the goal of closing escrow next Wednesday, June 9th, and then for the second phase of the campaign, which includes an endowment for management of the property and resolving the remaining outstanding parts of the campaign, including paying off those debts. So I just want the record to be clear and the public to know that there's still, it is very important to continue fundraising efforts in order to complete that purchase. And we very much appreciate Ms. Plowman mentioning that. I just want to make that clear that we still have some room to go in that important effort. Secondly, I wanted to respond on the Busy Bee matter. As you're aware, I represent the Coalition for Responsible Cannabis, which was the petitioner in that action. First, that ruling was fact specific to that particular case and that permit, and your commission is familiar with that and understands the distinction between each permit that comes before you. So to the extent that's a roadmap for future projects, I think that only applies when the facts are identical or comparable. And I would also note that the ruling did not conclude that the EIR adequately addressed all of the issues. The core of that ruling was that because the litigation wasn't filed 30 days after the EIR was approved and certified, while we were still digging out Montecito, because it wasn't filed then, those challenges were time barred. And so there was not an adjudication of the merits, but it was a procedural denial of the challenge to the adequacy of the EIR. So I think that's important, just as a public policy matter, for your commission to know that there are continuing concerns. And in fact, members of your commission have identified some problems that you've had with the issues and treatment in the EIR. The coalition does intend to appeal Judge Anderley's ruling. And so this is not the final word on that case. And importantly, this is not the end of the coalition's involvement in cannabis issues and permitting at the county. In fact, this is a call for redoubling of that effort, working with your commission, working with staff, and working with the community, the cannabis industry, and those responsible members that are interested in making sure that their impacts are avoided and mitigated to the maximum extent possible. I think there's been some very encouraging developments, improvements in science and technology that are moving our community much closer to a place where cannabis can operate in harmony with existing neighborhoods and communities. And I think that's really where we are all trying to get to. One ruling, yes or no, is not the solution or answer. The solution is in ensuring that there is compatibility between this new industry, our existing agricultural industry, residential neighborhoods, residences in agricultural zones, and others. So this is an ongoing process, and we intend to remain involved and engaged before your commission. Thank you for the opportunity to raise these comments and make these points.
Thank you, Mr. Totillo. Mr. Villalobos, is there anyone else from the public?
Mr. Chair, no.
Okay, very good. Thank you. Okay, well, we'll move on to today's standard agenda then. Okay. Mr. Villalobos, could you read item 1 into the record, please?
Yes, thank you, Mr. Chair. The following is a hearing on the request of Cerro Traguero, appellant, to consider case number 20 APL 45, an appeal of the zoning administrator's approval of case numbers 19 CUP 62, 20 AMD 3, and 19 CDP 157.
Okay, and it appears there's a request for a continuance. Does staff have anything they would like to add? Ms. Triguero?
No, it's fine by me. I believe it's mutually amenable to both parties.
Okay, thank you. Ms. Lear?
Chair Farini and Commissioners, I see Mr. Singer is available, and perhaps he can provide a quick summary. There is a memo that was sent out to the Commission, but Mr. Singer, if you could just summarize that, and I'll leave you to that.
Thank you. Mr. Singer, good morning.
Thank you. Good morning. That is correct. We have a memo for the continuance from today until next week, if that's what the Commission desires. This was to provide a little bit of extra time for the applicants to provide some updated materials, as well as to better accommodate Mr. Guerrero's schedule. The extra materials have since been provided and are prepared next week, but they weren't able to get them in time for this week's hearing, so we were hoping to get it continued to next week and have everything prepared for that date.
Okay, thank you, Mr. Singer. So we need a motion from Commissioner Cooney.
Yes, thank you, Mr. Chair. I will move that the G&K Processing Building appeal be continued to June 9th.
Second.
Okay, Mr. Wilson.
I'm sorry, but I just want to confirm that we did do public comment on this before we take a.
No, I totally failed. So, all right. Planning commissioners, do you have any site visits or ex parte to report on this item? No. Okay, we had staff. And is there anyone from the public who would like to speak on this item?
Mr. Chair, I believe our public speakers have signed up for items number 2 and 3 on today's agenda. I don't have any speakers for the first item.
Okay, thank you. Okay, can we do a roll call vote, please, Mr. Villalobos?
Commissioner Cooney,
Aye.
Commissioner Bridley,
Aye.
Commissioner Park,
I'm confused. We're voting on what now? The continuance?
the continuance.
Yes.
Sir.
And did anybody second the motion? I was gonna.
Commissioner Blau.
Okay, fine. Aye.
Commissioner Blau,
Aye.
Chair Farini.
Aye.
Motion passes 5-0.
Thank you. Okay, Mr. Villalobos, let's move on to item 2.
All right. The following is a hearing on the request of Robert Ramey, property owner, consider case number 19RMM3, application filed on October 22nd, 2019, to strike condition 15 of recorded conditions of approval associated with the Ramey parcel split, case number, 10 of parcel map 14432, and to determine the project is exempt from CEQA pursuant to section 15270 of the state guidelines for implementation of the California Environmental Quality Act.
Thank you, Mr. Villalobos. And then planning commissioner site visits and ex parte? No. Okay, very good. On to a staff presentation then.
Good morning, Mr. Chair, members of the commission. I'll be presenting the proposal for the Ramey recorded map modification. The project site is located at 820 Cathedral Vista Lane in the Eastern Goleta Valley Community Plan area. At the Planning Commission hearing of May 5th, 2021, the commission recommended that staff return to the commission with findings of approval to modify condition 15, which is that no development should occur outside of the building envelope unless it is for access and fencing, to also include allowing drainage improvements outside of the building envelope. The proposed revised condition is, with the exception of driveway access, perimeter fencing and walls, and drainage improvements, no development, including grading, shall be permitted outside the building envelope. Staff recommends that your commission make the required findings for approval of the revised project, determine that the project is exempt from CEQA pursuant to CEQA section 15305, and approve case number 19RMM3 as revised. This concludes staff's presentation. I'm happy to answer any questions your commission may have. Thank you.
Okay. Commissioner Blau.
Yeah, thank you. That's, as I remember the meeting last time, that wasn't quite the condition I was hoping that we saw back here. I think the condition should recite that there'll be no grading outside the building envelope except as approved by the county grading department or the building department to install the required drainage devices. I mean, it's silly to me. They can't say, if I'm the chief building inspector and I want to have a different grading arrange or a different drainage device in there and require some minimal grading, so be it. So I agree we don't want to have mass grading on that project, but if it's required to properly install the drainage device, then it should be allowed.
Can we hear from staff on that?
Chair and commissioners, perhaps we could pull up the slide just one more time. And Commissioner Blau, just so that Ms. Brown and I can make sure we're capturing your comment, would it be appropriate to revise this condition to say and drainage improvements as approved by the county grading inspector, or grading and building inspector.
That would do it for me. I mean, the reality is that, I mean, if the county requires it to be modified in order that it properly drains, let's do that. I get that we don't want to allow him to increase the size of the envelope or to modify the slopes and the hillside, so forth. But if it's an issue of, protecting the downstream property from drainage issues, and you need some slight grading, and the county is requiring it, let it be done.
Mr. Wilson.
Mr. Chair, Commissioner Blau, I'd recommend a slight change to that recommendation. Instead of having it as approved by the grading inspector, my understanding, and Ms. Harris, you correct me on this, is that they would have to get a grading permit regardless of what activities they're doing out there. So if you want to have some latitude, I would recommend that the condition may be worded and drainage improvements as reflected in an approved grading permit.
That's great. Perfect for me. I just wanted to, if the county approves it to be done, and it's the proper way to do it, I want the owner to be able to do that without further restrictions.
Chair and commissioners, could we just take a 5-minute break just so that we can sort out? I just want to have a discussion internally with staff on the language that we're discussing right now.
It's 10 o'clock. I'm sure Commissioner Park needs one.
Well, let's go ahead. Commissioner Park, did you have a comment before we go on break?
Yes, I do. Just a suggestion, and something for staff to think about while you're working the language. I understand what Commissioner Blau was asking for, but I think staff has spent a lot of time on this, and actually the language that's there, I believe, actually incorporates what Commissioner Blau wants. I mean, it implies that there will be a permitting process for these things, and that'll go in front of the building inspector, and the grading would do that. So I'm not really sure you need to change the language, but that's something you folks can all talk about. Thanks.
Okay.
And I might not disagree in that this is a little different language than I saw on the slide presentation that Mr. Vilbo sent to us prior to the meeting. Doesn't read quite the same way. So my point is, as long as he can get the drainage improvements done and not have someone at the staff level say that he can't grade to do the drainage improvements, I don't care. So I just want to make sure we don't have a situation that we have a catch-22 here where it creates a problem for Mr. Ramey.
Commissioner Blau, the staff would not be, if a project had drainage improvements and it was signed off by the engineer, there would be no way for staff not to allow it as written.
So then it would be redundant language.
We believe it would be redundant, yes.
Okay. Okay, Commissioner Blau, can we leave it as is then? Staff believes this will work.
Yeah, like I said, this is not the same language that was on the slide presentation that was sent to me earlier today in an email. So as long as we clearly understand that he can do some grading if he needs to in order to comply with the drainage improvements as approved by the county, I'm good with it. And by my comments here, it's now part of the public record, so I'm not concerned that it's going to be a problem.
Yeah, and staff is in agreement. So I think that's good. Let's keep this clean. And then let's move on. We will not be taking a break. Let's move to Mr. Ramey now, please.
Okay. Thank you for having me. I'll limit my presentation to 15 minutes or less, as I've been asked to. And
Mr. Ramey, you're not going to get 15 minutes today. Okay, we've already had all of the discussion. You have about 5 minutes to discuss what's in front of you, which is just the simple language the staff has presented today.
Okay.
That's what we're discussing today is staff's presentation. I'll give you 5 minutes.
Well, okay. Well, the upshot of this, I think that the revised version of Condition 15 still presents the same problems as the original one for Condition 15. There are other issues with grading, for example, the remediation of the northwest slope, which was pointed out by Echo Solutions, which I think would be a good thing to do. There are, oh yeah, okay, very good. And there are, and that's up at this pink part at the top. There is an area, here's the building pad, that's about 3 feet lower than the rough grade. I think that permits the structure, and here's the structure, to be lowered 3 feet and diminishes the impact on the neighborhood. And on the right-hand side, we see a thing that says landscape area here, which basically would permit one to make the level of the final grade the same as the pad, so it can be planted and whatever. There'd be a 3-foot retaining wall on the right side, and then when one lowers the pad, the 3 feet, without doing anything, it would create kind of a berm around the edge, and that should be flattened out or leveled to match the original grade. So these are totally within what I think most people would consider reasonable and normal, and yet they conflict with the Condition 15 in both its versions. So I did have a meeting with the people at Planning and Development, and I asked them, what would I have to do, or what could be done to achieve this result? And the answer I got was that, to diminish the scope of the project, but that really wasn't sufficiently helpful to me. The current project is, the living area is 2,700 square feet, and the garage workshop area is 1,094 square feet. This is totally within the normal size of houses along the lane. And so I would like to see that the commission take my original proposal, which is to strike Condition 15 and vote upon it, and then we'll see what happens. All the things that have been brought up as concerns and whatever, this project has to secure a grading permit. The grading ordinance I've included here is pretty definitive and pretty reasonable and pretty functional, and I have utter confidence that the planning and development departments that checks or issues the grading permit can guarantee that any grading done to make this project happen will be totally within what everybody considers reasonable. I think I have more faith in the planning and development departments, whoever it is that the grading permit process, than anybody else. So I think that concludes my presentation. I have included it in writing here. I have this plan that you see here, plus the other drawings are somewhat tentative because this project is still subject to the architectural board review, the planning department, the grading permit process, demonstration with compliance with the Goleta Valley Development Plan, which is required. I think it is compliance with it. A demonstration of compliance with requirements for stormwater management, which it's not exactly clear how that would work out in detail, but I feel confident that we've addressed that well. And I have everyone, nobody's objected to this project on its basis or on its merits. It's really just the problem that it conflicts with condition 15. And I don't see any reason why the commission should be concerned about just eliminating that condition. So I'm done with my presentation. I'll take questions. Which this is probably hopefully the last time that I will be able to address the commission. I do want to say that although I've butted heads with several commission members on occasion, I honestly feel that having concerned citizens doing this job is very important. And I think that commission, even the ones I disagree with, are working in very good faith, trying to do the best they can, and for the county as well. And so the fact that we have this conflict, to me, is it's not personal in any way, and I'm going to trust you to use your good judgment. I don't think it's a great idea for us to try and micromanage the wording in this condition to try and make it better on the fly while within the planning commission meeting. That's kind of how we got into this problem in the first place. So not to belabor the point, I think what I would hope is that you take my original request and vote on it, and then we'll be able to wrap this up.
Thank you, Mr. Ramey. I think Commissioner Blau has some questions for you. Commissioner Blau? Unmute.
Sorry. Mr. Ramey, I would disagree with you. The condition 15, to where you have no grading outside the building envelope, is kind of standard and appropriate for this project. I totally agree that staff misinterpreted that condition to not allow you to do drainage improvements on outside the building envelope, but to restrict your project to building envelope is appropriate. Now, you are right. If you present finalized plans to the BAR and the county grading and so forth, and by God, you're into 2 or 3 feet of the outside your building envelope to make minor grade corrections, my guess is they're not going to complain. They're not going to do anything. But you now have your ability to do the drainage issues, just to resolve them, that are outside the building envelope. And quite frankly, if you can't design your house within the building envelope, or you find that a 1 or 2 foot encroachment at some point in the future stops you from going forward and it's detrimental to your project, come back to us, we'll look at it. By then we have finite, I get it, but it's not going to happen. It doesn't work that way. What we don't want is you out there 10, 15, 20 feet and doing grading, raising something up 6, 7 feet. But if you're talking about a foot or 2 in the perimeter, and quite frankly, it's a BAR recommendation, it's not going to be an issue. But I think you should accept the language and go forward and go build your project. That's my thought.
Thank you, Commissioner Blau. Commissioner Park?
I have a question of staff relating to Mr. Ramey's comments. Would now be the right time for me to ask staff about that?
Please do, Commissioner Park.
Yeah. Mr. Ramey said that one concern of his is that some important work to be done would be remediation of the kind of loose, unconsolidated fill that's on the east side of the project, and that's different from drainage improvements. And so that this modification of 15 wouldn't work. Is there something about condition 15 or the other conditions that would prevent him from remediating that fill on the east side? Or in other words, is there a mechanism for remediating that fill on the east side so that we don't need to go through this whole process again?
Chair and commissioners, staff's understanding is because there is the building envelope in place, really the development should occur within that envelope. So I'm not so certain why there would need to be remediation work done outside of the building envelope in the ESH area if the development itself is within the envelope. Staff returned to your commission today after the May 5th hearing and Our understanding was that the drainage improvements were something that the commission wanted to see added. We subsequently had a Skype meeting with Mr. Ramey to discuss the project and understood that there were potentially other elements outside of what we believed the commission had requested us to return to, and we only returned with the drainage improvements. During that meeting, the conversation included things like landscaping outside of the building envelope and other elements of the development. Since then, we've also looked at the 2016 land use permit that was submitted prior to this recorded map modification. Part of the reason for the recorded map modification being submitted was because of that 2016 land use permit that showed that the proposed development at that time had some elements, roof, patio area. It looked like some hardscaping, potentially landscaping, and grading that were outside of the building envelope, all of which, because of the condition, are not elements that staff would normally support outside of an envelope and within the ESH area. So I hope that helps just clarify where staff is, what staff's recommendation is. I know that was more than what you asked, Commissioner Park, but I just wanted to put that on the record.
Good day. Commissioner Blau?
Say again? I know, I got it too far away from my mouse. I don't think that over excavation, recompaction is considered grading. I mean, quite frankly, in most projects that I build, I don't care where they are, we typically dig down for 3, 4, 5 feet, pile the dirt up to the right or left, and then put the dirt back in so that our grade is exactly the same as it was when we started. The difference is it's now no longer loose, it's compacted, so if I put a foundation on there, it doesn't sink. So if Mr. Ramey has an area of the property that has uncompacted dirt, and it's an issue for any reason, and he wants to dig it out and put it back so it's the exact same contour, exact same level, except now he has taken out 3 feet of dirt, he puts it back in 6 inches at a time, little water. When he gets done, it's compacted dirt. It's no longer loose, no longer shifts. If he puts anything on it, it doesn't sink. So I don't think that's a grading issue. I'm not sure what Mr. Ramey is talking about, but if it's outside the building envelope and there's loose alluvial dirt there that needs to be taken out and recompacted, that's not grading. It's just simply recompaction. And I'll let County Council correct me if I'm wrong, but in all jurisdictions that I deal with, that's not a cut and fill operation. That's just simply a removal and recompaction.
Commissioner Cooney?
Yes, Mr. Chair, I think we need to move to a vote on the condition we have modified. I'm concerned that we're starting over again with additional issues. I know Mr. Ramey would like us to. And if the majority of the commission wants to back up and continue this for further hearing in the future, that's great. I don't think we have time today to do that.
Thank you, Commissioner Cooney. I'm in agreement with you. Okay. Do we have any public comment on this, Mr. Villalobos?
Mr. Chair, we do. Mr. Teichman, Erwin Teichman, I am in receipt. Your email was forwarded to me this morning regarding presentation material. I did respond. Just before you start, I just want to let you know that we don't allow members of the public to share their screen.
Okay. Am I commenting now? I don't know.
Yes, you are, Mr. Teichman. You have 3 minutes.
Yeah, I just want to say I'm on the western slope of, you're talking about the eastern slope of recompaction And I'm in favor of Mr. Ramey being able to put his house at a lower level, digging down. I'm in favor of anything that helps runoff be alleviated towards my property, which is on the western slope. I have photographs that would have illustrated that. Perhaps those can be shown during the excavation process. So, it sounds like I'm not going to alter anything from what you have already decided. I just want there to be an alleyway for runoff from our lane between his new property and my property. And right now I have concerns about that. So that's my only comment. And so if the home were pushed further back away from my property, and I'm talking 6 feet, it would allow an alleyway for runoff from a fairly substantial amount of water that comes down the lane between our properties. And the way it's situated now, he's kind of shoving that alleyway towards my property to the point that I was forced to mediate that whole situation by putting in a $20,000 concrete driveway this past month and slant it away from his property. Anyway, I'm still concerned to the point that I designed a wall that can go between our properties. So that's all I was going to say, that anything that would help mediate that runoff between our properties, give me more room so that in a heavy, heavy rain, I don't feel like it's going to be on my front porch. So if this helps me, I'm in favor of it. If it helps push his property back a little bit from my property, I'm in favor of it. However, I can show, he's already removed about 100 cubic yards of dirt. He's talking about 500 cubic yards more. And I'm already feeling like I'm in jeopardy there for negative runoff towards my property. So that's all I want to say.
Okay, thank you, Mr. Teichman. I guess the question for staff would be, in regards to Mr. Teichman's concerns and comments, is there a pathway for him to make sure this project does not negatively impact him with drainage?
Mr. Chair.
Chair, if I could just weigh in. Unless the county grading department makes a mistake and improperly plan checks the project, that will not occur. That's part of the reason that you submit plans to the county so that those situations don't occur. Again, it's like, I don't know what to tell you. I mean, it's like you submit your grading plan that are drawn by an engineer. If Mr. Ramey were to concentrate and adjust the flow of water and damage his neighbor's property, he has civil liability. And I don't know if the county ever has any liability, but that's one reason you pay plan check fees. It's what you do with your civil engineer. He would certainly have liability. I don't think it's going to happen.
Okay, thank you, Commissioner Bob. Staff, do you have anything to add to that?
Mr. Chair, just that the BAR would also be reviewing any future development on the property for setbacks and making sure it's not right up to the property line between the neighbor.
Okay, and so then he could take his concerns to the BAR when they have those meetings.
Mr. Chair, that's correct.
Okay, and that's publicly noticed.
That's correct, yes.
Okay, thank you. Mr. Villalobos, any other public comment?
Mr. Chair, not on this item.
Okay. Mr. Ramey, do you have any rebuttal?
I just want to add a couple of comments. Mr. Blau suggested that if the BAR looked at this and found it satisfactory, that the in particular, this grading along the northern boundary which would flatten the backyard area and create and support this wall. Then it would be subject only to the planning and development grading permit process. And the fact is, the only reason that I'm here, and the only reason that I made this application, was that the planner involved in this process has refused to permit this plan to be submitted to the BAR because her interpretation is that any kind of grading, landscaping or whatever, between outside the building envelope but within the property line is not permitted. And so I think that at least the planning department and Mr. Blau's interpretation of what the planning department does are not quite in sync. And now I think I just heard the sound was not perfect, but what I got from one of the I think one of the members of the planning department right here was that if the BAR thought that the landscape would be improved by making this kind of adjustment, this condition would not prevent that. That's the first time that I've heard that. Commissioner Park, a couple meetings ago, specifically asked members of the Planning and Development Department if that condition would prohibit cutting a trench through outside the building envelope. The grading ordinance is very clear that it's not, and yet members of the planning and development have interpreted that in fact it is grading. So the only reason I'm here in the first place is because if things work the way that Mr. Blau suggested, we wouldn't even be here because the project already would have gone through, for better or worse, the architectural board review process. So kind of out of sync as far as, what the actual planner that's reviewing this project is permitted or not permitted and authorized or not authorized to do. It's extremely difficult to get a definitive explanation of why something is one way and why it's not. And it's all due to the ambiguity of this condition 15.
Okay. Thank you, Mr. Rainey. Commissioner Bradley?
I thought we were done with public comment and I didn't think this was an appeal, so I'm not sure about the rebuttal, but I'm hoping that we're back to deliberations from the commission. It is my district. I did not support the request for the change in the language when we heard this earlier, and I know Commissioner Park and Blau and you felt differently, so I respect that, but I would call the question and ask for a motion on the language presented by staff. I believe that we are getting way out of field, and if this needs further discussion, then let's continue the item. But staff did exactly what we asked them to do. They came back with an allowance to have the drainage improvements outside of the building envelope. I have my reasons that I don't want to spend time articulating why I don't support it. But let's just go with the matter before us. It's fairly simple, and I'm hoping that someone who supports his request can make a motion to that effect, because I will be voting against it. Thank you.
Thank you, Mr. Ridley. This is Commissioner Blau. I will make a motion to support staff's recommendation as presented.
Commissioner Park?
And I will second that. And so I second the motion, and I specifically want to say that I support what Commissioner Bradley has just said. It's time to do this one. I've been thinking about this. I appreciate the comments that Mr. Ramey made about members of the commission, whether they agreed with him or not, acting in good faith and doing their best. I think that same praise should be extended to staff. It must be hard to be a staff person sometimes, because you're pushed to get work out really quickly on major projects, and then sometimes you're doing the opposite, where you're facing the same thing over and over again. It's like, Sisyphus rolling the rock up the hill, and this one is becoming that. This matter first became before us, I think, in around Christmas time of 2019, and here we are today. we've committed a heck of a lot of resources from the Planning and Development Department, from this commission in dealing with this. I always like to look back and say, well, what could we have done better? We, planning staff, the applicant, planning commission, and I know what I could have done better is I wished I'd made a motion in December of 2019 to do just what this motion is. And let's get really focused and say, okay, if you want to make a change in condition 15, don't throw out the whole thing, but make a specific change that addresses a specific problem. And we have finally gotten focused to do that. So let's vote on it.
Okay, let's vote. Mr. Villalobos.
Commissioner Cooney.
No.
Commissioner Bradley.
No?
Commissioner Park.
Aye.
Commissioner Blau.
Aye.
Chair Farini.
Should have taken that break.
Are we
Yes.
now?
Motion passes 3-2.
Sorry. I apologize, Mr. Villalobos. I think I was anxious to take a break. You can maybe do that now, Mr. Chair?
Yes, why don't we take a 10-minute break and then we'll come back to item 3.
Thank you.
Okay.
Thank you.
Mr. Chair, we're back on the air.
Okay.
We're ready to begin.
Okay, thank you. All right, well, we'll reconvene. And Mr. Villalobos, we're going to move on to item 3 on today's agenda, please. Would you read that into the record?
Yes, thank you, Mr. Chair. The following is a hearing on the request of Drum Canyon neighbors, William Hines, Michael and Ellen Dearberg, and Brian and Shamra Strange, to consider case number 21 APL 13, an appeal of the planning director's approval of case number 18 LUP 275.
Okay, thank you. And do planning commissioners have any site visits or ex parte?
Yes.
Commissioner Bridley?
I spoke with Gallery Macon for the appellants in the last few days. Thank you.
Commissioner Park?
I have also spoken with Gallery Macon relatively recently. I just can't remember exactly when, and also with Amy Steinfeld, and I can't remember if we reported ex parte visits at the first call of this matter. But I also had a meeting on site with Young Jacobson and Patty Meek, and then also near on site with Billy Hines and Tyler Thomas. And those are my ex parte contacts.
Okay, thank you. Commissioner Cooney?
Mr. Chair, I'm pretty sure I reported a conversation with Amy Steinfeld and her clients when we first heard this matter, but I've had nothing since.
Okay, thank you, Commissioner Cooney. Yes, and I've spoken with Amy Steinfeld and with Gallery Macon on this project. I'm also familiar with the location. It was some time ago, but I did view the property with the CEO's office at the time. Okay, well, let's move on. Ms. Lair, I see you're active there. Do you have a staff presentation for us?
Good morning, commissioners. We do. Ms. Elkurdy is the case planner for this project and will be doing the presentation. So with that, I will hand it over to Ms. Elkurdy.
Thank you.
Good morning, Mr. Chair and members of the Commission. My name is Dara Elkurdy, and I'll be presenting case number 21 APL 13, a request by the Drum Canyon neighbors to consider an appeal of the approval of case number 18 LUP 275, a land use permit for the Sun Valley Ranch Cannabis Cultivation Project. The land use permit approved 40 acres of outdoor cannabis cultivation under hoops on a 348.51 acre parcel in the Ag 2 zone district. As shown on the vicinity map before you, the project site is located at 7369 Highway 246 in the Lompoc area, approximately 0.47 miles north of Highway 246. The project is bounded on the northeast and west by existing agricultural operations, and the project site is approximately 3.73 miles west of the city of Buellton. And the subject property was most recently being used for non-cannabis agriculture. The project was approved by staff under a land use permit on January 19th, 2021, and was appealed by the Drum Canyon neighbors, including Michael and Ellen Dearberg, William Hines, and Brian and Shamra Strange, on January 29th, 2021. Following the appeal of the project description was revised to further clarify that the existing residence is not a part of the cannabis project, that no cannabis will be stored on site, and that the source of potable water for employees will be bottled water. The project presented before the Planning Commission today includes the revisions mentioned in the prior slide, and I'll now present an overview of the project description. The property is a 348.51 acre parcel located in the Ag 2 100 zone district. The total proposed acreage of cannabis cultivation is 40 acres, all of which will be grown under 12-foot tall hoop structures. The water usage of the project is projected to be 88 acre-feet per year, which is 45 AFY less than the historical agricultural use of the site, which included the cultivation of tomatillos, peppers, squash, and hay. The site is developed with an existing 1,201 square foot residence and a 255 square foot concrete patio. New development proposed as a part of the project includes a 120 square foot security kiosk, 7 320 square foot C-train containers for storage, and 24 5,000-gallon water tanks. The project also includes installation of gates, fencing, security lighting, and landscape screening. The proposed operation would require 5 full-time employees with an additional 12 temporary employees during harvest and planting. On the site plan for the proposed project, you can see Highway 246 running adjacent to the southern property line in yellow. The parcels outlined in purple and the 40-acre cultivation area is shaded in red. The proposed guard shack and C-train containers are located over on the southern end of the property, and screening of the project from public views on Highway 246 would be provided by landscaped areas and are shaded in green. The appellant cited 7 main issues as the basis of their appeal. The 5th appeal issue cites violation of CEQA since the proposed project was not adequately evaluated under the PEIR, and it states that additional environmental review is warranted. Under the 5th appeal issue of CEQA violation, the appellant provided 3 arguments, which are presented under appeal issues 5.A, 5.B, and 5.C. The remaining 6 appeal issues cite a vague and incomplete scope of cultivation, an inadequate landscape and screening plan, an inadequate site transportation demand management plan, an inadequate odor abatement plan, inconsistencies with the comprehensive plan, and a lack of evidence to support findings. I'll now present an overview of the appeal issues and staff's response, which are addressed in full in the staff report. For Appeal Issue 1, the appellant asserts that the project description, site plans, and scope of proposed cannabis acreage are vague and incomplete. In response, staff finds that the project description is consistent with the site plans and provides adequate detail regarding the scope of the proposed project, which includes up to 40 acres of outdoor cannabis cultivation. Furthermore, conditions 1 and 2 of the project description require any deviations from the project description to be reviewed and approved by the county for conformity with land use permit approval. For Appeal Issue 2, the appellant states that the odor generated by the proposed project will conflict with surrounding agricultural operations. In addition, the appellant states that changes in the Right to Farm Act now make odor abatement on Ag 2 zones feasible. In response, staff finds that the proposed project does not require the implementation of an odor abatement system pursuant to Section 35.24.075 of the LUDC. For Appeal Issue 3, the appellant states the landscape and screening plan creates a hedge-like appearance, which is disproportionate to the surrounding landscaping. The appellant also states that the landscape screening must be supported by a performance bond. In response, staff finds that the landscape and screening plan has been enhanced to include a variety of plants, including California lilacs, toyon, coast live oaks, oleanders, and Leylandi cypress. The variety and staggering of the proposed plantings will avoid a uniform hedge-like appearance and will fully screen the project within 5 years. In addition, Condition 27 of the project requires the operator to cover the cost of installation and maintenance of landscaping prior to permit issuance. For Appeal Issue 4, the appellant states that the project's site transportation demand management plan lacks specificity and is inadequate to achieve sufficient trip reductions. In response, staff finds that the STDMP prepared for the project complies with the LUDC. The STDMP includes the use of incentives for employees who rideshare, including gift cards and preferred parking spaces, and the required findings can be made. For Appeal Issue 5.A, the appellant states that the LUP required for the project is a discretionary permit, which requires compliance with CEQA and allows the county to use its authority to review, condition, or deny the project. In response, staff finds that the project was adequately evaluated under the Cannabis Program PEIR. The project was determined to be consistent with the development standards for cannabis cultivation in Section 35.42.075 of the LUDC. Staff also made the findings of approval for a land use permit. Since the project was appealed, the County Planning Commission is now the decision maker for the de novo review of the project. For Appeal Issue 5.B, the appellant states that project-specific review under CEQA is required and that the Cannabis PEIR did not adequately evaluate the proposed project. Additionally, the appellant states that the project will cause new and severe impacts to aesthetic and visual resources, agricultural resources, land use compatibility, and air quality, which requires additional project-specific CEQA review. In response, staff has determined that the proposed project was adequately evaluated under the Cannabis EEIR, and there is no new information or changed circumstances which would necessitate additional environmental review. Staff completed a written checklist for the project pursuant to CEQA Guidelines Section 15168C4 and determined that the environmental effects of the project were covered in the PEIR. The project includes implementation of mitigation measures identified in the PEIR to reduce its contribution to cumulative impacts. A biological resources assessment was prepared, which included a comprehensive analysis of the study area. The BRA identified California tiger salamander as having a low potential for occurrence. In response, the project applicant worked with U.S. Fish and Wildlife Services to obtain an incidental take permit and purchase of conservation credits to mitigate for potential impacts to CTS. The previously certified PEIR, together with the CEQA checklist and supplemental documents, is adequate, and subsequent environmental review is not required. For Appeal Issue 5.C, the appellant states that the board adopted changes to the Right to Farm Act after certification of the PEIR have made odor mitigation on Ag 2 zoned parcels feasible. They state there's new information regarding pesticide drift and terpene contamination, and that the cumulative impacts of odor within the Drum Canyon Road area were not analyzed. For these reasons, the appellant claims that additional review under CEQA Guidelines Section 15162 is required. Staff responds that the PEIR did anticipate changes to the Right to Farm Act. The same methods and techniques for odor abatement that exist now, including carbon filtration and vapor phase systems, were available, feasible, and widely known at the time the PEIR was prepared. Cannabis activities within the Ag 2 zone districts were exempted from an odor abatement plan requirement. The PEIR considered the presence of biogenic volatile organic compounds, VOCs, including terpenes, and concluded significant and unavoidable impacts. Their existence and alleged impacts are not new information, and there continues to be a lack of evidence that terpenes from cannabis cultivation result in impacts to the quality or marketability of surrounding agricultural crops. The use of pesticides by conventional agriculture and the accompanying regulatory framework as analyzed in the Cannabis Program PEIR is the same now as when the PEIR was certified. Pesticide drift was not and still is not allowed. Lastly, the presence of wine tasting rooms was known at the time the PEIR was certified. Pursuant to CEQA Guidelines Section 15162, no subsequent environmental document is needed. For Appeal Issue 6, the appellant states that the project is not consistent with Goal 1 of the agricultural element, and the appellant also states that the project is inconsistent with the open space element of the comprehensive plan, and therefore should have been subjected to heightened design review. In response, staff finds that the project will continue the cultivation of crops and is consistent with Goal 1. The open space element determined the relative scenic values of areas and identifies a 2,000-foot buffer for major county and urban study roads, which requires design review in these areas. The cannabis cultivation area is located outside of the 2,000-foot buffer. Additionally, the project is not within a county-designated scenic area or the design control overlay and is not subject to design review. For Appeal Issue 7, the appellant states that the Commission cannot make the required findings of approval based on odor drift caused by the proposed project, the visibility of the project from Highway 246 and Drum Canyon Road, and the inconsistency with Goal 1 of the agricultural element. In response, staff finds that the proposed project was reviewed by staff and was found to be consistent with the LUDC cannabis regulations, applicable LUDC regulations, including zone district requirements, and the county comprehensive plan. All findings can be made for the proposed project based on substantial evidence. Additionally, the proposed project has adequate services to serve the operation. Water will be provided via a well, which pumps from the Buellton Upland Subbasin. The proposed cannabis cultivation activities will result in a decrease of water use on the subject parcel. It will not exceed the county's groundwater threshold of 22 AFY of net water increase for this particular subbasin. Water use will be approximately 88 AFY, which is less than the historical use of the property, which is approximately 133 AFY. In conclusion, staff recommends that the Commission deny the appeal, case number 21 APL 13, make the required findings for approval for case number 18 LUP 275, determine that the previously certified PEIR is adequate and subsequent environmental review is not required pursuant to CEQA, and grant de novo approval of the modified project, case number 18 LUP 275, subject to the conditions set forth in attachment B of the staff report. This concludes staff's presentation, and we're now available for any questions. Thank you.
Thank you. Any questions of staff? Commissioner Park?
I have 3 different kinds of questions. So let me march through them and I'll try and be as quick as I can. Could you briefly comment on, or just describe this kind of, I guess you call it a water course that's on the west side of the project, and just what implications it has for this case?
Yes, Commissioner, through the chair. I believe the water course you're referring to is an ephemeral drainage. So they had, I believe it was a 50 or 100-foot setback, excuse me, I can't remember off the top of my head, that was required by the State Water Resources Control Board.
Okay, and let me, and I don't mean to diminish the importance of that, but I want to jump on to my other questions. Your first staff report refers to the agricultural policies that may apply. And I want to compliment you for that. Reasonable people can agree or disagree as to whether these policies bear on the case and whether they bar something or don't bar something. And that's what we're all here for. But I think it's very important that the policies at least be stated and brought to our attention because they are relevant. And your report did that. So again, I appreciate that. There's a comment immediately after goal 1 of the ag policy that says it is the intent that this policy only applies to non-agricultural development and its effect on agricultural policy. I don't want to debate that right now. My own position is different, and I've been doing this for decades. But what's important to me is to know whether your recommendation, okay, rests on this finding that the ag policy just doesn't apply. Because I think we actually could apply it, and then we would debate whether or not it makes a difference or not, and it may not here. But it's important to me to know whether your recommendation is based on the argument that the policy absolutely does not apply to this case. Can you answer that question?
Yeah, Commissioner, through the chair. The way that we are interpreting that goal is that way, which seems to conflict with your position on it, but we are considering cannabis to be an agricultural activity. We believe that that goal's intent was to protect agriculture from non-agricultural industry. So part of my recommendation does rest upon that.
Well, let me put it this way. So I'm kind of trying to throw you a softball here. If you were to find that it does apply, but in fact this is not a violation of that policy, would that change your recommendation? I mean, does your recommendation require that you find that this policy does not apply? Would you reach a different result?
Commissioner, through the chair.
Commissioner Park, I think we're a little confused.
Yeah.
If you could clarify for us, I mean, staff is saying that this project as proposed is consistent with all the agricultural policies before them. We do interpret the agricultural policy that you're talking about as that ag should be protected from non-ag uses that could prevent or hinder agriculture from continuing. And what we are saying is that this project does not do that. This does not hinder agriculture on an adjacent project in any way.
Well, I think your response was confusing. My question wasn't, so I'll explain what I'm doing here. I think that the ag policy does apply. And then when you apply it, you can debate whether or not, in fact, there's a violation of that policy here. Okay, so I can disagree with the comment that it doesn't apply at all and still reach the same conclusion. And that's why I'm asking you, can you only reach the conclusion that that this is an appropriate project by taking the position that this policy absolutely does not apply, it's irrelevant? Or can you reach the same conclusion by saying, yeah, we can apply it, but when we apply it, we can find that it doesn't bar this project?
Commissioner
Is that
Park,
clear?
Well, no. Are you saying that we omitted a policy that you would have liked to have seen? We're just a little confused. Is there a policy that is not in our analysis that you would like us to comment on? Or is it in the analysis and you're disagreeing? We're not clear what you're asking.
Okay, I'll say it again and I'll try to draw a picture.
Mr. Chair, I'm sorry, can I respond to
Yeah, go ahead.
Park's comment? So I understand Commissioner Park's comment. He wants us to make a determination as to whether or not we would say it's compatible with this policy, not that it doesn't apply, and that the cannabis grow is a compatible agricultural crop. Is that correct, Commissioner Park?
Well, I don't think that the word compatible I think the use of the word compatible implies a stronger standard than is there, but you're more or less there.
So I'm looking at the policy right now, and the essence of the policy is that agricultural operations remain to a major viable industry in Santa Barbara County, and that agriculture shall be encouraged and essentially protected, right? That's goal one. Enhance the continuation of agriculture. And I believe, I haven't talked to my staff about this because this question is just coming up in the hearing, but I would say that if you, coming from your perspective, if you felt that this applied, then I would say yes, the cannabis application is agriculture and it is part of the viable production of agriculture in Santa Barbara County. So does that answer your question? We're talking about goal one, right?
I think I think it does in so many words. The point being that even if we disagree whether we have to apply these policies or not, but if we do apply them, it doesn't mean we bar the project. It means we go through a factual analysis to see if there's a problem or not. And we might say, yeah, we will apply this policy, but it doesn't mean we bar the project. It is not inconsistent with the other agriculture. And in fact, I think that's actually what Judge Anderley's decision touched on, and it's an argument I've made in other projects. It's a case-by-case item. So I think at least you're telling me that your recommendations don't rest solely on the argument, which I think is incorrect, that the intent of this policy is not to apply to other agricultural projects. That you can still reach the same conclusion, just do it in a somewhat different manner. And so I'm going to ask a similar question about the Will Vizuete study that's referenced in the supplemental memorandum. It's interesting for me to see that study referred to in so many staff reports and in fact incorporated in it. I had a conversation with Mark Byers about it, and he's basically behind the company that Mr. Vizuete worked for. So it's a somewhat one-sided study. It has some, I don't want to say holes in it. It's very accurate as far as it goes. It was not intended to be dispositive. And I think it surprises some folks that it gets referred to so much in this context. Nevertheless, we've never seen any study that says that there is terpene deposition on cannabis. So it doesn't mean, even if one questions the Vizuete study, that we somehow accept the argument that cannabis can't be grown because there's a terpene deposition problem. So I'm going to ask the same kind of question I asked about the policy. Do your recommendations rest entirely on the adoption of the Vizuete study concerning terpene deposition, or can you reach the same conclusion without reference to that study?
Before staff says anything, Mr. Chair, I'd just like to make a remark that I think what's stated in the staff report is that we don't have any evidence before us that of this alleged terpene taint. We don't have any. And we do have some information about bioorganic volatile compounds, right? So VOs, we have information about that, and that they're abundant, that they're just as strong in pine trees and rose bushes and rosemaries as they are in cannabis. So what we're trying to do is give some context to the commission about that. We're not relying on Mr. Vizuete's study, we're just providing information. So I would say we are relying on the fact that we don't have any evidence to the contrary, that it does create an impact and taint a wine grape. In fact, the evidence that we do have came from a study in Australia on eucalyptus, and the results of that study actually said it had more to do with leaves getting into the soil and leaves getting into the actual wine barrels than anything else. And they couldn't really demonstrate that there was this eucalyptus taint on the grapes in that study. So we're trying to give the Planning Commission as much information as we possibly can, but we're in no way relying on Mr. Vizuete's study. It's just information about VOCs and what exists in the environment.
I think that's very well stated, because but I think you've hit the nail on the head. What we're looking for is there evidence of a terpene deposition problem? And if there is, somebody ought to prove it to us instead of just saying it. And I can remember when we first heard the Hacienda matter, grow matter, which was in 2019, and Mr. Vizuete's study first came up. I moved to continue the matter for a couple of months so folks could comment on that study and initiate studies of their own. And I know that these studies can cost money, and we'd like to have the county do it. It hasn't really gone anywhere, but somebody ought to be able to afford to study this and provide evidence on this point. But that evidence isn't there now. And so I think you've hit the nail on the head, and I thank you for your comment.
Sure.
Okay, not seeing any more questions. Then let's go on to the appellant testimony.
Good morning, Mr. Chair and Commission. My name is Brianna Strange, and I'm here on behalf of Strange Family Vineyards. My family lives on the property that is abutting the proposed farm. I sent in a PowerPoint last night. I'm not sure if you have that, Mr. Villalobos.
I did not receive a PowerPoint from you.
Okay, can I re-forward it to you right now? Is that enough time to load it up?
Sure, go ahead.
Okay, thank you. Okay. Okay, I just resent it, so please let me know if you have any issue opening that. Or is there a way I can put it on my screen and share it? Is that easier?
I'll expand on the, I'm still waiting for the email, I apologize. But as I further expand what I made a comment on for the last item is we typically don't allow either members of the public or even our applicants to share their screen. That's why material has to be submitted ahead of the time. We need it for the record anyhow.
Okay, I'm gonna get that to you right now. We were trying to negotiate a deal until very late last night on this, so I apologize for the delay in getting you this presentation. While I'm waiting for that to upload, maybe I can address a few points on the staff report that we just saw.
Mr. Chair, the secretary wasn't here. My recommendation, we take like a 5-minute break to get loaded up because I don't want to take away from Ms. Strange's time on this. So it might be more beneficial if we take a break to load it up. I don't know if it's came in yet.
Not yet.
Okay. All right. Well, Ms. Strange and Mr. Villalobos, if we're on break, why don't you both stay in contact somehow so you can get the presentation loaded. And we'll, and do we really need to leave the meeting or can we just wait until it's done? Figure it's going to be 5 minutes or somebody needs to go. I don't know. What if it's done in 2 minutes?
Saying 58 seconds on my end.
Until he gets it?
Yeah, it's looks like the file was big, so I'm putting it in a Dropbox link so he could just open it that way and it doesn't get stuck in the email.
Okay, that does sound like about 5 minutes. Okay, let's take a 5-minute break.
Mr. Chair, we're ready with the presentation. I was able to download that, and so just give our CSB TV staff a moment to put it on to broadcast that.
Okay, thank you, Mr. Villalobos. And there it is. Okay, Ms. Strange. Let's
Great,
try it
thank
again.
you. Apologies for that. So first, before I get started, I wanted to touch on a few points that we saw in the staff report. First of all, the map that was shown in that staff report where it was shaded in red, that's 70 acres, not 40 acres. That map is incorrect. It does not match up with what is in the project description. So that's one issue. Another issue is that the findings in the staff report are all boilerplate responses that have nothing to do with this specific property and the issues for this specific property. Commissioner Park, you pointed out that some of the studies have holes in them. I mean, it's an understatement. To rely on those studies to support this specific application is really nonsensical. The other thing that came up is the setback from the waterway. That's a huge problem for this property. The fact that the staff report doesn't even have in there what the setback is, could be 50, could be 100. I mean, that's a focal issue for us here. So it's concerning to me that that's not even a key part of the staff report. One other issue before I move on to the PowerPoint is Commissioner Park, your question about whether parts of the ag policy should apply to this. The ag policy should apply to ag activity. I mean, cannabis has been described as an agricultural activity, which is fine, but that means the same policy should apply to this as it does to any agricultural activity. Part of that has to do with odor. There needs to be reasonable measures taken to prevent odor of any crop. It doesn't have to do with cannabis or not cannabis. It has to do with if the ag element is met, and here it's not, which we can get into later. I also want to note that ride sharing gift cards are going to be really insufficient to address the drainage issues that we're looking at for this project. Okay, so to the PowerPoint. First, I want to make an edit to the first page of this. This is on behalf of the Strange family and the Hines family. We tried to reach an agreement. We spent the last 72 hours negotiating with the applicant, but there are some really critical issues here that we couldn't get past. We thought that this should be brought to the commission's attention. Should I wait for Mr. Chair to continue? Sorry, can you please go back to slide 1? Mr. Chair, should I wait to continue?
No, go ahead.
Okay, did you hear my first points? Are we all good on that?
Yes.
Okay. All right. Our appeal today is not about cannabis. We have no issue with cannabis. It's about an unsupported proposal in an area with severe water runoff issues. The crop could be anything and the application problems are the same. Earlier, there was a mention of the recent Busy Bee decision, and I want to emphasize Ms. Richardson's point that this is not the final appeal of that case, and that decision could be reversed, so it's not a case that the commission can rely on in reaching any sort of conclusion on this project. Busy Bee is also very, very different from this project. Okay, next slide, please. At the outset, the application is facially deficient. The project description does not match the site map. It is off by 40 acres, does not show where the hoops are going to be placed, and does not contain information on fresh, frozen, or autoflower impacts, which Sun Valley has told us they were going to use. The transportation management plan does not address maintenance of Crawford Canyon Road. This is a road that is not maintained by the county. It is subject to easements and it's a shared road. The county cannot assign rights to it without reference to the operative easements, which it hasn't done in the staff report, nor has the applicant done in their application. The proposed grow runs along an easement that's prone to washing out and which the applicants have wholly ignored. The applicants talk about how much money they've spent on this project to date, but somehow they have not addressed the basic issue of property rights and hydrology. Again, we want to reach an agreement with Sun Valley and we are close to doing so, but the LUP as it is cannot be approved. Next slide, please. In order for this project to move forward, 3 key findings must be made. First, no significant new effects or the CEQA finding. Second, the project has adequate public and private resources. And third, the project is compatible with the comprehensive plan. Not a single one of these findings can be made today. Slide 4, please. As to finding 1, this project is unique. It's not like Busy Bee or the other projects compared to it. They are proposing multiple harvests throughout the year. That's 12 weeks out of the year that this property will be harvested and presumably planted an additional 12 weeks out of the year. The PEIR has nothing in it about perpetual harvest. The harvest is slated to take place adjacent to a dry creek bed that historically washes out, with zero information provided on how multiple harvests a year will impact the washout on our property. Nor has odor been addressed with perpetual harvest, nor is there consistency in the project description and with what the grower has said. With this particular method of harvest and a multi-month harvest in an area where applicants are planting along a private road not subject to county repair, granting this application without a project-specific EIR is going to be problematic for all parties involved today. Next slide, please. Okay, this is a photo of Crawford Canyon Road, which is the only driveway to my family's house. There's nothing in the application regarding road maintenance. And again, the county does not maintain this road. The PEIR says nothing about 3 months of harvest impacting this road. It's also silent on hoop farming on historically unstable land. If this project is granted as is, knowing all of that, will the county agree to take over maintenance of the road that abuts the proposed grow? Again, should I wait for the chair to return or should I keep going?
You know, why don't you run your show? The chair is here.
Okay.
And the slide has not advanced, by the way. We're still on the perpetual harvest slide.
Okay, can we go to the next slide, please? Our concern here is that we as the neighbors are going to have to pay for something that the county is granting without having seen the operative easements. Can we at least agree that this road has a history of washing out and that we should understand the impacts of harvesting 3 times a year with 17 employees before pushing through this land use permit? It's imperative that the land use application acknowledge the easements, maintenance, and ownership rights on Crawford Canyon. As of now, it does not. The transportation management plan fails to meet basic requirements, and the applicants, as of last night, had never reviewed the easement documents for the area adjacent to where the hoops will go and where the road washes out. Although this project has been in development for a while, the applicant has not done proper due diligence on the property lines and easements. The water board is aware of this issue and is planning to visit the site. The Hines family has been in contact with Alyssa at the water board. All we are asking for is the proper due diligence to be done. Without more, the LUP cannot be granted. Next slide, please. Can you all see that on your end? Next slide. In 2019, the applicant put up unpermitted hoops. He was caught and the county stopped the project. We are still staring at the mess from this almost 2 years later. We have very little faith, unless it's in writing, that we can rely on the applicant to maintain the road once he's granted an LUP. The LUP should not be granted without an understanding of what the county is granting to the applicant relative to the pre-existing recorded deeds. Next slide, please. We've already addressed this, but I'll point it out again. The cultivation area shows 70 acres. The project description is 40 acres. It shows us nothing about where the hoops are going to go, and we can only assume that they're going to go along the unstable part of the road that is adjacent to my property. Second, the transportation management plan ignores all the issues with Crawford Canyon. It doesn't say the size of the trucks or how often any of the harvests are going to happen, but we know from the project description, the harvest will take place 12 weeks out of the year. Third, the project description is incompatible with what the grower has told us, and it lacks information on perpetual and frozen fresh harvest. Finally, the applicant's evidence that there is no ag conflict is based on other projects like Busy Bee that have zero applicability here. Busy Bee was half the size, had odor control, and did not use perpetual harvest. In fact, it prohibited staggering grows. The applicant merely recycled evidence from a totally different project. References to Busy Bee in this context are irrelevant. Next slide, please. We cannot tell from the white shaded 70-acre area where the 40 acres of hoops are going. The project is also completely abutting our property despite the existence of 300 additional acres. If the 40 acres are against our property, we have a major issue with the swales and hydrology on the creek bed, but the applicant hasn't looked at this part of the project and again saw the easement documents for the first time last night. Next slide, please. We want to address this now at the planning stage to avoid what could turn into years of litigation. We are willing to work with the applicants here. If we can do open air grows or understand how the impacts of perpetual harvest will change the washout on the easement that abuts where the hoops are going to go, we are happy to move forward. But as it is, we do not have enough information. Next slide, please. Next slide, please. A land use application should not, or excuse me, a land use permit should not be granted for a sliver of land that is historically unstable without the proper studies and plans. What the applicants have to date does not address the hydrology issues or the road maintenance. Next slide, please. And next slide, please. Okay, so looking at Ag Element Policy 1E, I believe this is what Commissioner Park brought up earlier. The land use permit would allow for perpetual harvest and zero odor abatement. This is unheard of and in no way constitutes reasonable measures as required by the Ag Element. If the argument is that the Ag Element doesn't apply here whatsoever and this shouldn't be considered at all in a cannabis project, I think it's a very different conversation. We feel strongly that it does apply here because this is an Ag project and this is an Ag Element. So if it does apply, the conclusion has to be that there is not sufficient odor abatement because there's zero odor abatement. Next slide, please. At the heart of this all, the application suffers from a lack of transparency. A half dozen different entities have been affiliated with this project. The letters of reference in support of Patty Meek are nonsensical. Patty Meek is listed on various Secretary of State filings and appears to be a straw man for the owners. There are no letters in support of the actual applicant, Young Jacobson. We have no idea who will maintain the shared road. The application has changed ownership several times. We've been told that Young Jacobson is trying to push this project through so he can flip the property and make a profit after installing illegal hoops a few years ago. We, the neighbors, will be left to clean up the mess. Next slide, please. Even in light of this, we are willing to reach a compromise, but that compromise needs to be accurately reflected on the land use permit. Otherwise, a private agreement is taking over the jurisdiction of this commission. Next slide, please. We respectfully ask this commission either deny the application, require amendments to it, or grant a continuance. We can make this work, but not with a legally deficient application. Rushing this project through now without the necessary project details only serves to harm us and the applicants. Thank you.
So, Ms. Strange, are you done with your presentation?
Yeah.
And you have no other parties with you then, just you?
No, we have Galloway who would like to say a few words.
So you're not done?
Well, my presentation is done.
It's your time.
Yeah, you're part of a team. So we're hearing from Ms. Macon now.
Yes, hi, Chair Freeney, members of the commission. My name is Galloway Macon with Flowers and Associates, and I'm here to speak on behalf of the Hines family. I've been working with the Hines family on a cannabis application for the past almost 2 years, and they thought I would be a good person to help mediate between the applicant and the appellants, given my experience with cannabis projects and most notably the Sunstone project, where it was a similar situation with appellants and the compatibility of uses between wineries and cannabis. So I've been working with the applicant team, which I would want to give some appreciation and thanks for their hard work. And I think that we've gotten really close to a resolution, and it sort of fell apart this morning. So we're here before you now but there were some really good things that came from those discussions. And there's a solution where everyone sort of walks away with what they want. And I think given, there's a couple ways of going about it. If they had an odor abatement plan, then that could give some assurances. Otherwise, the project just needs to be reflective of those setbacks and possibly moving some of the acreage to the other side of the canyon. As Brianna Strange said, eliminating hoops. But there is a way to reach a neighborhood agreement and working with that community. So I'm here to answer any questions and offer support, knowing, having the experience that I have with cannabis projects. Thank you. Oh, one last thing. Sorry, one last thing. I do want to say the Hines family has a development plan application in for a really beautiful winery. And that is in very close proximity to this project. And that's been the biggest point of concern for them in particular. They would like a setback of 1,500 feet from that winery to the cannabis plant. And that would still allow for lots of acreage on the property. And they've spent millions. They've spent millions on getting the vineyard in operation, and they've spent years working on that application, and they're close. So this sort of derailed their process because they got several applications that came in for cannabis around their property, and they're just trying to have a consistent message of setbacks from wineries for that protection, given that these land use permits don't require any odor abatement plan. So that's just my pitch for the setback and for the Hines family. Appreciate any questions or any feedback.
Okay, Ms. McCon, looks like you have a few questions here. We'll start with Commissioner Bradley.
Thank you, Mr. Chair. I'm not sure, maybe staff can put a slide up, but I want to understand the discrepancy between the 40 acres in the project description and the 70 acres shown on the red polygons in our exhibits. Because if you understand what the applicant has said in terms of how that's going to be managed or moved around, I'd like to see the picture so we all understand why that's a source of disagreement still. And then secondly, if we have an exhibit up, can we look at this 1,500 foot setback that Ms. Macon just recommended?
1 second, Commissioner Bradley, we're going to pull something up for you. There we go.
Thank you very much.
Maybe I can answer that, Commissioner, through the chair. So prior to myself having the project description had it written as 70 acres, and then I later read the bio report, which only had 40 acres written in it, and I clarified with the architect several times, and she let me know that they were referring to the entire project area, so the entire fenced area rather, but excluding the setbacks and the roads and other uses, it was only actually a 40-acre area that was going to be cultivated.
Okay, well, I guess I'm confused. Well, I think that acreage in red totals 60 acres, am I correct? And where in the fenced area, it's hard for me to read the plans at this scale, and it was hard for me to read them online even. So I'm struggling with if the polygons are the area where it's going to grow. I mean, obviously we have fighting neighbors here, and so the clarity of the exhibits and where this grow is going to occur, I think, is important for both sides. So are these red polygons 70 acres or 40 acres? Or you're saying they're 70 acres, but biologists recommended 40 acres max? I need clarity.
Yeah, let me clarify. So the entire fenced project area is 70 acres, but only 40 acres of that is to be used for cultivation.
What is the red area showing?
The red area, so if you also look on the site plans, you'll see the hatched area is where the hoops are going to be. And that is what the red polygons are covering.
Commissioner Bradley, through the chair, if I can just add into what Ms. El-Kurdi described. So the project site itself, including the fencing, roads, parking area, storage containers, that's all enclosed within a fenced area. And that total acreage is 70 square feet. However, within that area, you know, there are several roads for folks to kind of access roads to get to the cultivation sites, for parking, for water, etc. So if you look at the cultivation footprint of the cannabis itself, that is proposed as 40 acres. So the disturbance footprint, if you will, is 70, which includes non-cultivation, but the cultivation area itself is 40 acres.
Ms. Laird, on that, so do you have a slide depicting where the 40 acres is within the 70-acre site envelope? I think that's what some of the commissioners are asking for.
Sure. Perhaps Ms. El-Kurdi can pull up attachment D. That's the project site plans, and that might provide a little more clarity and something that we can zoom in on to kind of show the commission what we're talking about.
Super.
Is this the site and planting plan, Ms. Laird? That's where you're referring to the crosshatch? Okay.
So unfortunately, just due to the layout of the site, it's hard to get it all on one plan set. So what we can do is once we pull up attachment G, just looking on the first page of the site plan, and if Ms. El-Kurdi can zoom in a little more, maybe to that top portion, and a little more. There we go. Actually, maybe a little more. Sorry. There we go.
Yeah, that helps.
So, and Ms. El-Kurdi, maybe you can, I don't know if we can see the cursor there, if we can do some sort of pointer. But if the commissioners take a closer look, you can see the outlines of the hoop structures where the cultivation will be located. And these are generally depicted in the boxes with some more of the gray cross-hatching. Unfortunately, the line weights aren't very heavy, so it's not easy to see, especially on a smaller screen on a computer. But these kind of smaller squares are the proposed cultivation areas. And as the commissioners can see, there's a note there. Hatched areas indicate 40 acres of proposed cannabis under hoops. Ms. El-Kurdi, if you could actually zoom in one or two more, just a little more close. Thank you. So the 40 acres is really under the hoop houses and cannabis cultivation only. As the commissioners can see, you know, there is distancing that includes a 50-foot setback from the property line, as well as some agricultural roads to access these cultivation areas. So when totaled, there's about 30 acres that are non-cannabis cultivation and 40 acres that are cannabis cultivation under hoops. And we've done our best to clarify that in the project description, and those were some of the revisions that we had made on appeal, just to make it abundantly clear to the appellants as well as the commissioners that the cultivation that's being proposed is really only 40 acres.
So I have a couple more questions following up on that. Should I continue?
Yes.
Mr. Chair. Okay, that helps with the zooming in. And then There's another exhibit in our packet. It's the site and planting plan, which shows, quite a few diagonally striped spaces, parking spaces and landscaping. And I guess I'm not really sure where that is along this rectangular shape of the cultivation area. Can one of you guys help me on that? It's a sheet L2 site and planting plan.
Commissioner Bradley, can you clarify again? You would like to see the parking layout, and what was the other?
Yeah, I know it's hard because you guys don't have a mouse, but where is this parking layout and the landscaping buffer is somehow around the planting plan and the cultivation area. I guess I was looking for where is that on the exhibit that Ms. Al-Kurdi just had up. Right there. So where is that? Where is that? Where are those sections in relation to the cultivation area?
Commissioner Bradley, through the chair. So that area is south of the cultivation site. I believe it's a little funky with the layout, so it's hard to get it all on one side, and perhaps Ms. Al-Kurdi can correct me if I'm misspeaking, but as I understand it, the parking area and what you're kind of looking at on the left is kind of on the south, maybe southwestern end of the cultivation site. And perhaps if Ms. Al-Kurdi can scroll up to one of those first pages, she can point it out when we're looking at the overall site plan there.
I'm sorry, I really appreciate the rest of the commission letting me understand the graphics on this. I think it's probably helpful because the question that it begs is you're telling us that there's 40 acres within a 70-acre red polygon indicated area and that the remaining 30 acres are for things like landscaping, parking, and roadways. But am I understanding that that parking area and the landscape screening is outside of the area fenced as cultivation area? Is that how I'm reading this?
Commissioner, through the chair, the parking area, there's also some shipping containers and staging area. That's all included in the 70-acre fenced area.
Okay. Okay. Yeah. One other question, maybe it's premature, but so Ms. Macon talked about, and as did Ms. Strange, talked about working on this appeal and some sort of an agreement up until this morning. Could one of you just summarize for me what are the points that you think you could still find consensus with?
Sure, I can do that. I apologize, I don't know how to say chair, Miss.
Through the chair, Commissioner Bradley would it be how you address me? Yes.
Thank you. Okay, Okay, that's what I was
Bradley is how you pronounce it. Thank you.
Bradley.
Yeah, you can just answer the question. Fine.
Yeah. So we had an agreement on a lot of the key issues here, but what happened at the end of the day is that, as you can see from the drawings that we just went through, there's no clear demarcation of where the hoops are actually going. So then we got into this question of, okay, well, if there's a setback of 1,500 feet and the hoops are all being pushed up at the top, can we do an open grow on the hoops that are right in front of our house just so we don't have the hoops right there? And part of the issue that we really ran into is that the drawings we just looked at really do not show us where the hoops are going. And then, that sort of led to, okay, well, how far can the road be paved? And then it was, well, we can agree to pave the road, but we don't really understand like where the easements are or sort of that. And so it just felt difficult to reach an agreement at the 11th hour with some of these issues outstanding. And again, we want to try to work it out, but we didn't want to give up our chance to appeal without having something in place on those really key issues.
Okay, thank you.
Thank you.
Commissioner Park.
Got to remember where we are. I think we're asking questions of Ms. Macon, and question is, you refer to setbacks you'd like to have and so forth. Could you elaborate on what's the distance between this proposed tasting room and where the closest cultivation would be, and also the distance between the vineyard for your clients and where this proposed cultivation would be? And if you know the distance between the Strange's vineyard in residence and where the cultivation would be. I'd like to get those numbers.
Chair Freeney, Commissioner Park. Right now, and I apologize, I'm not prepared. Again, we're hoping to reach a settlement, but we can certainly get graphs to show those distances. I believe the proposed location of the winery is about 300 feet from the cultivation area. And just to speak on that cultivation area again, because I don't think we have full clarity, my understanding is that those boxed areas that are shown on that site plan equal 70 acres, but that they want to use 40 acres of that area for cultivation. So I work at an engineering firm, so we measured it, and that is about 70 acres. And they want to have the flexibility of, maneuvering and, having workspace, but it's within the 70 acres of those boxed areas. And then the Strange family, I think Brianna can speak to the distance between their house and the grow. So all we can assume is the full outline. And they want a setback from their winery tasting room specifically. They're not asking for a setback of their vineyard. They just for where the winery is going to be located.
Mr. Chair, Commissioner Park, we are still trying to figure out exactly what the setback would be on the proposed plan, because we still don't know from these schematics where the hoops are going. But from some of the written language we've seen, it looks like it will be the minimum setback required, which I believe is 50 feet.
Commissioner
Well,
Park?
certainly, just one last comment. It would certainly be useful if any of the parties are asking for setbacks, if they can indicate how far that would push the cultivation back and where it would push it to, because that's you're asking us to do that, and yet we don't have the information to do that. Thank you.
Thank you, Commissioner Park. Commissioner Blau?
Yeah, I'm just a little concerned that we don't have the appellant asking us what they want us to approve. We don't have the applicant, whatever the applicant yet, asking us what they want to approve. It sounds like we shouldn't be here today. It sounds like we should continue this for a week. And if they can get to an agreement, that's great. If they can't, then have each party specifically give us a diagram and a list of what they wish us to approve or deny. I mean, it's kind of like, it's kind of goofy. I don't really want to spend the afternoon trying to figure out what the different parties are asking for when they don't know themselves today. Am I missing something here?
No, in fact, I'm in agreement with you, but I'm not sure if procedurally we can just stop the meeting and move on with a continuance.
Well, I agree with that one. I think you can certainly hear from the applicant now, and unless I hear something more definitive, I think we can just, after that in public hearing, continue it and be done with it, and they can come back a week from now with an appropriate set of exhibits and requests.
Okay, well, let's, if there's no further questions of the appellant, then let's go ahead and move on. I don't know what to do, guys. It's lunchtime after this. So then, Commissioner Park, are you in need of that hour? for lunch?
Well, yes, yes.
Yes. Yeah. No.
I don't need it right now.
All right. Well, let's go ahead.
Yeah.
And
you know what I would. May I make a suggestion?
Yes.
May I make a suggestion? We've heard from the appellants. I think the applicant is going to have maybe 10, 15 minutes at most. I think we should hear from the applicant, and then I think we should address the question that you've just addressed, Chair Farini, and Commissioner Blau has, that maybe there ought to be a continuance. I think Commissioner Bridley has asked some very good questions, and they really weren't answered in order to have a good, clear graphic representation of what we're doing here. I have questions that I'm not really getting answered. I kind of think that we should continue this for a short time to get more clear information of what the parties want and to give them a chance to finish their discussions. And I'm also mindful of what Commissioner Cooney has said, not about a continuance, but about his desire to be done with this by, I think it was 2:15. So I think that we should hear from the applicant right now, and then we should address this question of where we go with this hearing today.
Okay. And I'm just being extra careful with my fellow commissioners because sometimes I forget and just push these meetings on, and 15 minutes turns into an hour. So I think it's okay if we continue, but if at some point somebody needs a break, please just speak up and we'll take the break.
Mr. Chair,
Commissioner
I
Bradley.
would totally support what Commissioner Park said. If we can get through the applicant's presentation and then take a break and move from there.
Okay, so let's move on to the applicant's presentation.
Good morning, Chair and Commissioners. I'm Amy Steinfeld, Counsel for Sun Valley. We're thrilled to be here. It's been exactly 3 years since we applied for this project. There was no rushing. We clarified many items in the project description to confirm that this project will not exceed 40 acres of cultivation. I do want to address, this continuance. We spent not just this long weekend trying to settle this case, but there's a long history going back, more than 6 months. We actually delayed issuance of the LUP to try to reach agreement. As you know, it's very difficult when you have more than one party. We've offered millions in concessions, but we just can't get to a yes. So we are here today to ask for a vote. I also want to introduce my team. Sun Valley Ranch is owned by Young, but he has hired BDZ to operate the project. Patty Meek and Aaron Levy are here. I'm also here with Karen Streeter, the agent and architect here. She can answer all of the detailed questions about the project description. So with that, I'm just going to turn it very quickly over to Ms. Meek to talk about, her background with this project. Next slide, please.
Good morning, Commissioners. I'm Patty Meek. I own and operate BDC Incorporated. As far as my background in agriculture goes, I spent 22 years in Colorado on Meek Ranch, raising purebred Simmental cattle, Arabian horses, and 1,600 acres in hay in a no-till situation. After I left Colorado, I came to California. I got my degree in nursing. For the next 12 years, I was in nursing, which gave me a firsthand experience on what hard chemical pharmaceutical drugs was doing to my patients. At that point, I was living in Humboldt County in Northern California and started in earnest researching medical cannabis for an alternative to these hardcore drugs. The chemical drugs, in a lot of cases, made my patients even sicker. Medical marijuana was an alternative that was safe, non-addictive, and cured a lot of the same symptoms and a lot of illnesses. Okay, and that kind of brings us up to date on me. And now I'll turn it over to Aaron Levy. He is my cultivation manager. Aaron?
Good afternoon, Commissioners. I just kind of want to speak briefly on the history of my experience within the cannabis industry. I've had over 10 years experience in the legal aspect of cannabis production. I've had currently to date over 35 inspections under my belt with 3 companies spanning from San Jose down to Santa Maria. I've been in detail with the CDPH, CDFA, Fish and Wildlife, BCC, and other entities. I will have a little bit of bragging today to say that the last 2 inspections that I just received in the Salinas Greenfield area, I actually got a inspection with the only notes that said, "Good job," smiley face. With that being said, my primary focus is to produce and maintain a compliant product that is not only good for the end user, but also being a good land steward to the area. I could go on in detail, but I'm not going to today. But long story short, every single project that I've started and developed in California, which exceeds over 35 acres, every single property that has been fallowed or abandoned has been in a better condition after I've finished the project than when it was before. If you guys have any other further questions, Amy can also refer you to any other resources on my behalf. There are some links and some other information, but for the most part, that's it.
Okay, thank you, Aaron. And I just want to point out that this cute little white house that you see, Patty resides on this house, located on the property. You've probably passed it on the 246. It's a historic house. So she will be living there in order to manage the project. Next slide. Here's a little bit more about Aaron, as you heard. Next slide. So I just want to point out this project is really ideally located on the historic Dominguez Ranch, as you heard, nearly 350 acres. It's away from any urban centers, over 8 miles from Lompoc and 4 miles from Buellton. And then there are no EDRNs in the vicinity of this project. Next slide. Here's a photo of this ranch looking towards Highway 246. So you access it on the very southwestern corner. We will not be utilizing the main part of the road and never driving up near the Strange family. We understand that the Strange family has decades, if not centuries, of that road washing out, but this project does not propose to use any of that road, and this project does not have an easement over that road. On the right of this photo, you can see why Young and BDZ picked the historically irrigated part to site the cannabis. On the left side, you can see the fact that this ranch is really comprised of very steep hills. Cannabis can't be grown on steep slopes. In addition, if you look at the hills on the left dotted with the oaks, this area will be continuing to be used for ranch land and grazing. So the great thing about this project is that the cannabis is going to take up about 11% of the entire ranch, but most of the ranch will remain as is. So the neighbors will continue to see these beautiful hills. And Patty, as you heard, has a long history of cattle grazing. So they are continuing to lease this property out for cows. Next slide. You can see, although there's not many residents in the area, here are a few that will remain. Next slide. So Dara did a great job of summarizing the project, so I'm just going to address some of the issues we heard from Ms. Strange. There's no perpetual harvest. This is no different than any other project. We clarified the project description. There'll be up to 3 harvests a year. We're going to try to plant the 40 acres over, a 2 to 3 week period, but given we want to account, Aaron needs to account for labor shortages, weather, so they're giving themselves up to 30 days to plant, which means there could be up to a 30-day harvest period. There will be solid wood fencing along the canyon. Crawford Canyon Road, it did get sign off from not just Caltrans, but also from County Public Works. So they determined that this 16-foot wide all-weather road was accessible and would be appropriate for this project. This project is really a very low footprint because we took out all the processing. So there's only going to be 5 full-time employees and 12 seasonal employees. So again, it's a very small footprint on the road. All employees will be encouraged to carpool. With regards to the flood, there was one incident. It was isolated, and that was due to some metal being placed in the lower parking lot area. That issue was immediately remedied. Young emailed his neighbors and immediately hired a construction crew to come repair the road, to put new gravel on. The road was never impassable. With regards to the concern that there somehow had never been studies about Crawford Canyon Road, I want to point the commissioners to Exhibit E to my letter that I submitted yesterday. There was a very lengthy site management plan that was submitted to the regional board. And in fact, that report found that there was no erosion, there was no concerns over sediment, and with the 100-foot setback from the ephemeral creek, plus all the other best management practices that are incorporated here, there would be no concerns over sedimentation, erosion, and the regional board and the state water board signed off on that. So I think it's important to correct the record that there was lengthy studies done over the concerns that we heard from Ms. Strange, and those state agencies determined that there was no issue. The great thing about cannabis, unlike other crops, is it's subject to water conservation plans, so they have to utilize drip irrigation. So if you look at the baseline use where they irrigated veggies and hay on site, they didn't have to comply with the setbacks, with the water conservation. Cannabis actually is going to be a really great addition to this historic ranch. You're not going to have any discharge or erosion issues. In fact, it's illegal under the state regulations. Next slide.
Can I stop you, please, Seinfeld? Can you back up to slide 1, please? Can you tell me who owns Crawford Canyon Road?
Sure. So we have looked into this, and the lower part of the road is actually owned halfway through the road by Mr. Young Jacobson. When he purchased the property, also part of the road came with that purchase. Once you get past, it's really, section 3.5 of the ranch, it goes on, it makes a jog and it goes up onto the Strange property. And that particular upper part of the ranch, which again, this project will never utilize, is subject to an easement between the very northern property owner and the Strange family. And I believe there's been some litigation over that particular easement, but the easement has nothing to do with Young's property. With regards to the road itself, the county has determined that it was intended for public use. And so based on that, we have, offered to landscape up to that point at which it turns up onto the Strange property.
Well, the portion of the Crawford Canyon Road that you're accessing for the benefit of getting access to your client's property is it owned by you and maintained by you? Or you're telling me that beyond that is maybe owned by somebody else and maintained by somebody else currently under litigation? Did I get that right?
Yeah, so yes, so the lower part of the road, the Crawford Canyon Road piece that we will be utilizing is owned by Young Jacobson. The county does not maintain it. They've made that clear to us. And so Young is taking responsibility for maintaining the portion of the road that he will be accessing and that he owns.
Okay, and does other people use that road as well to get to the other portion of the road?
Yes, so the Hines family utilizes, the turnoff to get to their proposed winery. I believe under their CUP for the winery, they're going to have to pave that road. And then the Strange family also utilizes that portion of the road to access their upper vineyard and residential property.
Okay, those are my questions. Thank you. I didn't mean to interrupt you, but I didn't want to have to come back to the slides, yeah.
Okay, so let's see, let's go to the next slide. Here's just touching on some of the green sustainable aspects of this project. As you heard from Aaron, he's very excited to get his hands in the dirt and to really restore this historic ranch, which was utilized for years of hay and veggie growing. Next slide. Again, I think there was a question about how far these various other uses are. So you can see from this map really just how remote this canyon is. And when Young was looking at properties, he wanted to make sure he had a property off the 246 and that would not be subject to public view. So you see on the left, the only existing tasting room in the area is the Deerberg Star Lane. That's 2,600 feet over the hill. The Strange residence is 630 feet from the proposed cultivation site. Another woman, Bev, lives to the north about 900 feet. So just to give you an idea of where everything is. And then the Hines family, about a year after this project was submitted, applied for a CUP for a wine tasting room. Currently, the proposed site is about 360 feet from the proposed cultivation site. And there was a question about setbacks. You know, we've looked at 1,500 feet. It just takes out too much of this prime soil, sections 1, 2, and 3. So 1,500 feet was not something we were able to accommodate, but we were able to accommodate a smaller setback. Next slide. Again, you know, we've heard this a lot, and this of course came up in the Busy Bee case, but we believe that cannabis is compatible with the neighboring uses. BDZ and Young Jacobson fully support the proposed wineries and are excited to add to, you know, the ag uses on these properties. So we think we can all be great neighbors. We don't see any incompatibility here. Something came up about hoops. I do want to mention the reason why hoops are needed for this project as compared to some other projects. The wineries and the grapes are located, you know, above the property. So in order to protect from any accidental pesticide overspray, we think it's a great idea to have hoops to prevent any conflicts. And then second, this area has a unique microclimate. It's actually a little bit colder and windier and foggier than other areas outside the canyon. So the hoops really protect from this, you know, these weather patterns and prevent mold and other things from getting damaged in the wind. Next slide. This didn't really come up, but I do want to mention we submitted a supplemental memo. And the great thing about this project, it'll actually result in a significant reduction in the water use in the area. There is an on-site well. It's not shared by any other party. And so this is a really good, you know, water efficient project. Next slide. As far as odor goes, you know, we knew there were concerns about odor. So all drying and processing of cannabis will occur off-site in Lompoc. So the product will be immediately cut down and put into trucks and taken to Lompoc for processing. There are substantial setbacks, right? So we don't believe that there's going to be, you know, direct odor issues. And then the great thing, we have nature helping us here. The prevailing winds, if you've been to the site, actually blow away from the vineyards and towards the eastern part of the ranch. So the only, I'd say, you know, folks that are going to be impacted potentially would be the cows that are on those grazing hills. And again, we believe the hoop houses will also help contain the odors. Next slide. Also, I know that BDZ and Young are excited to help beautify Crawford Canyon. There were cypress trees that were planted a few years ago. They are now actually extremely high. That prevents anyone from kind of peeking in through the 246, although, you know, it's set back quite a bit from the 246. And so the landscape is actually going to extend 2,640 feet up the entire border of the property. So these are some of the species we're looking at. Again, we're flexible if there's other species that either the neighbors or the commissioners would like to see. Next slide. There was a memo submitted by Mr. Mark Shatillo about tiger salamanders. So in response, we had Rincon Consultants take a look at their claims. And just want to confirm here that there was a full biological review done. There was numerous meetings with Fish and Wildlife Service, U.S. Fish and Wildlife Service, and they determined that because this project doesn't include removing any vegetation, that it was very unlikely that tiger salamander will be impacted. But because they were in the area and because hoops were proposed, they proposed that the applicant obtain a take permit via paying payment into these mitigation banks. And so this is a mitigation measure that's required as a condition to the LUP and has been fully signed off by the county peer reviewer and the wildlife agencies. Next slide. And I just want to close. These are a few of the last issues. Again, we fully support the compatible uses that are proposed. And we don't believe that there's any incompatibility here. And at the end of the day, I think BDZ, after waiting for 3 years, is just they're ready to get their hands in the soil and to get planted. So I'm happy to answer any questions.
Okay, thank you, Ms. Steinfeld. Commissioner Park.
I have a series of questions for you, Ms. Steinfeld. I'm going to kind of ask them in rapid order, so be ready. Is there any other area that's been cultivated on the ranch where some of this cannabis could be relocated from the area that's selected?
No, and after hearing from the neighbors, we did an extensive look at the history of the ranch, and this is the only area that has ever been basically used for row cropping. The rest of the ranch, it's always been a historic cattle ranch, and because of the CTS and other drainage issues, this is the appropriate area where the county and the wildlife agencies wanted to see cannabis planted to have, you know, the least disturbance on this historic ranch.
And so if we were to go into some of those non-cultivated areas and turn them into cultivated areas, we would be tilling potential tiger salamander habitat, would we not?
Correct, potentially. And also, you know, you have the fact that a lot of the ranch has very steep slopes and hills. And so, you know, you get into runoff issues and other issues that the regional board would not be happy about. Hoops really need to be sited on flat land.
Okay, and the hoops, the reason in your slide for the hoops is to protect from overspray, but then you seem to be arguing that there is not an overspray incompatibility between other agricultural lands and cannabis. I find that to be somewhat inconsistent. But how important is it that there are hoops on all portions of this grow?
You know, it's twofold. Because of the distances from the vineyards, we don't think that we're going to have an overspray issue. But again, we want to be super cautious since, again, the cannabis will be located downwind from the vineyards. So in case there was ever a high wind event, we just want to make sure they're covered. But really, in talking to the grower and understanding this microclimate, this is kind of the edge of the fog zone, and fog can cause mold to grow on cannabis. And so the hoops really protect from the fog, the super soggy conditions, and then also from high wind events, which can damage the flower.
And you mentioned hoops controlling odor. I'm sure you've heard the argument that hoops can concentrate odor until it's kind of burped out with a wind event, so it actually makes it worse. You've heard that before, correct?
I have heard that, but the great thing is the wind, you know, you've been there coming through the canyon. We think it's going to create sort of a natural AC condition where it's going to be pushed out.
Yeah. Were this permit to be issued, I suppose you bear the risk that it would be appealed to the Board of Supervisors. When does your client anticipate planting his first crop?
So I think like most other cannabis growers, since they had applied back in 2018, they were hoping at least to get a crop in this year. If we did reach a settlement, you know, potentially, but it's looking like at this point, 2022, if we go to the board. So we're prepared to take it through.
Okay, I'm going to laser in for a moment on landscaping, and that'll be my last questions. I'm just going to tell you something I don't like about the landscaping plan. A lot of things I really do like. I like the no-till agriculture here that the grower's talking about. I like a lot of the native plants that are in the landscaping plan. What I don't like is the oleander and the cypress. The cypress is not really a native plant. It's a hybrid that comes from a native, and it's what you'd see in a Jane Austen novel or something. And the oleander is freeway landscaping. It's poisonous to anything that touches it. I'm kind of surprised oleander is allowed next to a cannabis grow that's for human consumption. And I think that your wildlife there, which I'm very concerned about, not just what the neighbors think, but what the critters that can't speak think, will be much happier with all native landscaping. Denise Knapp, who's the director of conservation at Santa Barbara Botanic Garden, has written extensively on the use of native plants for windrows. What I'm wondering is, would you be willing to substitute out the oleander and the cypress, not pulling out the cypress that's already there, but the cypress that would be planted, and instead substitute in some native species? I'd name some for you: a hollyleaf cherry, coffee berry, coyote brush. They're already on site. I've seen them. If you didn't plant anything, they would probably take over a lot of what you intend to cultivate. They grow fast. They'd be very successful. They'd be very appropriate. Catalina ironwood would look very nice as well. So is that something that you'd be willing to do, to substitute in some of these native plants for the oleander and the cypress?
Absolutely. And, when we were working with our land site designer, these were the plants she recommended, but obviously you have a lot of local experience. And so happy to strike the cypress and the oleander in exchange for the native plants. And I do want to note, though, we will maintain some of the taller species because we want to make sure we have adequate screening.
The hollyleaf cherry and the Catalina ironwood would be, they'll grow to trees. I planted some 2 years ago. They're already twice my height.
Oh, wow. Okay. So those will satisfy the height.
All right. Thank you.
Commissioner Cooney.
Okay, I'll move on to other commissioners.
Thank you, Mr. Chair. I have a question for Ms. Steinfeld, who is a regular attendee at Planning Commission meetings. So I want to ask you, frankly, Ms. Steinfeld, we heard from the appellate, they were close to a resolution, and you indicated that you want a decision today. So I can see why that was not consistent with the resolution. So my question to you is, if you had a short continuance of this matter that might resolve the objections of the appellants for good, as opposed to the Board of Supervisors, do you think that would be something your clients would support or oppose?
I'll need to discuss with them, but my inkling, again, I'm a perpetual optimist, and under normal circumstances, I would think we could settle. But after seeing some of the terms that were removed or added this morning, I think we're too far away. We're dealing with 3 families. And so, I would prefer, again, if we didn't have the 6 months of trying to settle, right, it had just been this weekend, I might have more hope. But after seeing how far we're apart this morning, I'd like to proceed with the vote because I do think we'll be going to the board, unfortunately. Not to say we won't keep trying, but I just don't see this settling at this point.
Thank you. I appreciate your candor. It helps us in determining, because from the appellant's presentation, it appeared they were looking toward a settlement, and as a result, haven't been prepared as well as they should be to present today. Thank you.
Commissioner Blau.
Yeah, I was just following up on Commissioner Cooney's question for Ms. Seinfeld. It seems to me that the appellant has 10 days after our decision today, should we make one, to make the appeal to the board. So in essence, you've got 10 days to negotiate with the appellants. And if you can come to some resolution and they don't appeal, it saves them the $589 or whatever the damn fee is for the appeal, and problem is solved. But so far, from what I've heard from the appellant and what I've heard from you is that there's not a real issue that I think needs to be resolved. It's like, I just got the feeling they don't know what they're asking for at this point in time. And you're telling me that, the goalpost keeps changing, I guess, as of this morning, leads me to believe you're not going to get a resolution without some kind of a deadline, and the Board of Supervisors hearing could be the deadline for it. That's just my thought. But I agree with Commissioner Cooney.
Yeah, I appreciate this. And I think if you can understand, you have 2 people asking both for setbacks. So if both were granted, what's left is really what we're struggling with. But again, just want to remind everyone that originally we, Young and BDZ were trying to fit 70 acres into this historically, cultivated area, and they've reduced it to 40. So we do feel like that's reduced some of the concentration issues and concerns.
Ms. Steinfeld, so I've got Google Earth up here, so I'm a very dangerous engineer at this point. On the southern part of the grow area that you show, it looks to me if you moved in about 500-600 feet towards, say, the north, you'd at least satisfy that distance request for the Heinz winery of 1,500 feet, more or less. you'd get close and you would lose about 5 acres of grow ground. Is there a way you guys could look at maneuvering your project so that that southern area just doesn't have production, but you still have utility? It looks like that's where you were going to put your storage anyway, and maybe parking and your handling and all of that, if that were to occur. And maybe that just doesn't show up well on your engineering maps. It looks to me like a simple fix.
No, and that's a great question. And I'm just sort of laughing because we spent all weekend essentially doing these radius setbacks to see, what we could do. So at 1,500 feet, it takes out all of section 1 and section 2 and half of section 3. That's prime ag land. We also looked at, what a 500-foot setback would do at a radius from the proposed tasting room. At 500 feet, we would remove section 1. So we did look at various options, and we proposed something less than really the 1,500, but they weren't really willing to budge. And it's one thing to have the 1,500 foot setback from the proposed tasting room, but then you have the Strange family asking for their own setback. So then you start to get down to maybe just a handful of acres. And so to make this project viable, since, BDZ and Young they've purchased a 350 acre ranch, we really believe we need, 40 acres to make this project viable, not just for the next 2 years, but really for the long term.
Yes. Well, you have me at a double disadvantage. You are a great attorney, and I like the way you deflected that. So I really wasn't speaking about the Strange request on this setback. I was looking more at the winery. I have a different thought process on homes on ag land and their perceived impacts of agriculture on their home site. So, but as far as the winery and that being one of the main businesses of the area that the grow is moving into, I would like to see some effort made by your client to try your best to satisfy that, whether it's getting it halfway there, but finding a way to move your project. If you have 70 acres there, you ought to be able to maneuver if you're only growing 40.
Mm-hmm. Yeah, and I appreciate that. It's a little,
or I'll tell you, or I can ask for a continuance, and then we can really go in. No, I'm serious here, and we can go into depth on this, and you can come up with some other ideas or a better set of plans, so that we really know what we're talking about. But I'm not prepared to just let this thing go, because I think some of what we've received today is just not adequate, unless you're willing to discuss openly on some solutions.
And Chair Freeney, I appreciate that. And, I think what might make sense, I do want to make sure I talk to my client about this before I start kind of changing the project. Could we maybe have a short lunch break to discuss this and then come back?
Yeah, why don't we do that? Let's come back. And if you have any more information on the roads, I'd like to, if that's from staff, but the whole road thing doesn't seem to make total sense to me. So staff, if we have something already prepared and you can point me to that document, I'd appreciate that as well. Mr. Wilson?
Rookie mistake.
I believe you're muted.
My comments are in regards to timing. I think Director Plowman has some other comments. I think we were aiming at trying to complete at 2 or 2:15. Otherwise, we're going to lose a commissioner. It's 12:30 now. I know staff and I think Commissioner Park, they have an hour lunch break. So that puts us at 1:30, and we still have public comment to do on this item. Or if we continue it, we need public comment on the continuance. So just looking at time and timing, Just want to be cognizant of what we're trying to accomplish today by 2:00. That may be a discussion we have with the commissioners before we break.
Okay. Commissioner Cooney?
Yes, Mr. Chair, I didn't assume from the projection of the time involved here for our day that there would be a conflict, but I certainly don't want to impair the hearing. I feel particularly in this case that I can rely on my fellow commissioners to come up with the right solution or a continuance. I'd love to have another chance to participate, but since I'm inflexible, I think we ought to proceed on a normal schedule and take the break necessary for staff and Commissioner Park. And I will be staying as long as I can, but I probably won't be around for the vote.
Appreciate it, Commissioner Cooney. Okay, with that, we'll be back. Oh, go ahead, Bob.
I just wanted to say that I kind of agree that the issue of the road and the 1,500-foot setback from the winery is the only two issues I really have. I can't believe that if we don't come back here at 1:30 in that half an hour, we can resolve that so Commissioner Cooney can participate. And I'm looking at the participant panel. I don't think we have one or two public speakers, so that's 6-7 minutes, and we should be able to get done by 2:15.
Okay, Mr. Wilson, are you good?
I just have one final comment when we come back for Ms. Steinfeld and staff. There's some confusion or unclarity in regards to where the cannabis is actually growing on the site plans. So I think in order to get the commission to a place where we could take action, if that's the direction today, is if Ms. Steinfeld or staff together could provide some details exactly where the cannabis is growing. I think a couple of commissioners have asked that today. So the site plans are a little confusing as far as what's actually happening.
If they could do that and further documentation on the road and its true status on who owns half of what and all the easements. And then I would say forward those on to the commissioners in PDF as well as have them ready for public display. And with that, we'll adjourn and be back at 1:35. It is now. Thanks.
Mr. Chair, I think staff is ready whenever you're ready to begin.
Larry, you're muted. There you go.
Okay, well, let's reconvene our June 2nd meeting and continue on. Who was next? Commissioner Bradley, do you remember?
Shoot.
I think you want a public comment now.
Public comment, right? Public comment.
Public comment. Okay. Ms. Laird, do you concur that we move to public comment?
Sounds great.
Okay. Mr. Villalobos, about public comment.
Yes, thank you, Mr. Chair. I think we're down to just a couple of people. Our first speaker will be Nancy Emerson.
Chairman Farini, can you hear me?
We hear you, Ms. Emerson.
Thank you. Chairman Farini and commission members, WeWatch supports the appeal of Sun Valley Ranch's approval due to our concerns about the cumulative odor impacts from outdoor cultivation on sites west of Buellton. We spent time reviewing the odor control section of the EIR carefully, including Appendix F. It seems to us that indoor and outdoor cannabis cultivation odor control should not have been combined, and one conclusion made that odor control for both was feasible, meaning capable of being done successfully. The PEIR's Appendix F had several indoor cannabis examples using carbon ventilation or vapor phase, but the only outdoor example was not a cultivation site, but a landfill, whose staff reported vapor phase would be more effective in a closed area. Even indoor cultivation and processing were only feasible if a building was airtight. Carpinteria's odor problems come partly from this oversight. 3 years later, the only possible odor control for outdoor cultivation, vapor phase, is still somewhat unknown in terms of effectiveness, especially for those larger grows like the one we're talking about. The legal defense that no one challenged the PEIR or the ordinance in 2017-18 and the BOS statement of overriding circumstances unfortunately seem to block consideration of this issue. And I think that's too bad. Experience shows that the philosophical aversion to regulation of outdoor grows in the cannabis land use ordinance, now partially corrected, but still not achieved on Ag 2, was a big mistake. We think even agriculturalists agree now. We are frustrated that no more work has been done on Ag 2 regulations because no funding was provided by the BOS this spring. Meanwhile, Santee and Nez Valley and other county residents' lives will be more disrupted as the cumulative impact of odor increases. Thank you.
Thank you.
Our next speaker will be Leo Welder. moving on, I see that Mr. Welder used to have 2 places in there. I thought maybe he might be connecting via phone. We do have one speaker who's joining us via phone. If that's you, you might have to hit *6 on your phone to unmute yourself. So if the last 3 digits of your phone number are 776, hit *6 to unmute yourself. Perfect. Can you hear us?
Yes, we hear you now.
Okay. Good afternoon, Commissioners. My name is David Van Wingerden with Farm Lane, formerly CBW Organic Farms. I'm speaking in support of Sun Valley Ranch Cultivation. Sun Valley's project is a good project that is compatible with the surrounding neighbors in the industry. They are clean operators with diverse agriculture on their land. Cannabis only occupies about 11% of the entire property, which is modest and would have little impact on the land around it. This farm also utilizes many sustainable inputs and growing practices, including organic fertilizer, organic pest control, beneficial insects, no-till practices in order to preserve soil structure, and cover cropping. As cannabis operator myself, I can appreciate the challenges good operators go through in order to acquire their permits and demonstrate good cannabis cultivation practices. I encourage the Planning Commission to deny the appeal and allow Sun Valley to receive their permits to produce cannabis to allow this historic agricultural site to thrive. Thank you for your time and have a great day.
Thank you.
Mr. Welder, if you're having trouble unmuting yourself, I can give you the number to the hearing room and we can put you on speakerphone. We might have to move on in just a minute though. The number here is 805-568-2092. Again, 805-568-2092. Mr. Chair, I'm not sure how you want to proceed. I know that we have limited time. If you want to move on, if you want to come back, if Mr. Welder is able to connect, we can do that if you like.
Okay. Let's give him about half a minute here. And then we will be moving on to the appellant rebuttal and closing remarks. So if you can be prepared, if Mr. Welder doesn't speak, we'll start you guys up. Okay, Ms. McCon.
Chair Farini, thank you. It's Macon, but
okay, thank you.
It's okay. Chair Farini, members of the commission, I just wanted to leave you with just a few key points. I do think we're very close to a resolution, and I just want to make it very simple what the ask is. It's a 1,500-foot setback from the proposed winery, and that winery is in the county, so that can be pointed to. The application's in with the county. And then the Strange's family, they are not asking for a setback, so I just want to make that clear. They're not asking for a setback, they just want no hoops in sections 5, 6, and 7 of the site plan. And those are in the northern area. So in working with the applicant, there is another location on this property for up to 12 acres that can be moved. And I've been told by the applicant team that that is a desirable place. It is an option. They would have to submit a new application or amend this one to move it over there, but there is an option to move acreage and keep the total the same and not lose that 40. And then I'll let Brianna speak to the Crawford Road. I know that came up.
Thank you. Chair Farini and the commission, I just wanted to point out one last issue on the road. Earlier, Ms. Steinfeld said that Young Jacobson owned the road when it turns off Drum Canyon onto Crawford. but that's not true. That part of the road is owned by the owner of parcel 1050, which is on the bottom right there against 246. And I know that because my family owned it until a few months ago and we just sold it. So that's just an incorrect statement on who owns that road. And I think we still are a little bit up in the air on the ownership rights there. Thank you.
Okay, thank you.
Mr. Chair?
Yes.
Before we move on, I just wanted to throw it out there to see how you, I have Mr. Welder on the phone if you've left public comment open.
Okay, yeah, let's go ahead. Mr. Welder.
Go ahead, Mr. Welder.
Hi, I apologize for the technical issue there. I was Trundell had some issues, but my name's Leo Welder. I'm the president of Ada Scientific, a new cannabis testing lab in Lompoc, and I'm calling to encourage the Planning Commission to approve the Sun Valley Ranch project and deny the appeal. The Sun Valley team is building a project that will allow the 100-year-old Dominguez Ranch to continue to operate its cattle business while adding an exemplary, sustainable cannabis farming operation that has been designed with every consideration to avoid impacts on their neighbors. They have reduced the size of the proposed cultivation area from 70 acres to 40, meaning only 11% of the ranch will be used for cultivation. Additionally, the edge of the cultivation area is 200 feet away from the start of all neighboring vineyards and 2,600 feet, over 8.5 football fields away from the nearest wine tasting room, to my knowledge. I've commented in the past about the value of having great cannabis farmers in the community. They create jobs directly, and they are the foundation for building a thriving local cannabis industry that supports dozens of ancillary businesses, including testing labs like our own, but also local retailers and other local services like photographers, professional services, construction businesses, etc. I also want to personally comment on the importance of giving historical cattle ranching businesses the ability to generate income in new ways, so they may continue to exist. I also come from a multi-generational cattle ranching family and have firsthand knowledge of how difficult it is to maintain those operations. The margins are thin and the businesses are subject to an endless list of risks driven by the market as well as Mother Nature. A high-value crop such as cannabis that only requires a small percentage of the acreage to operate is a godsend to this kind of operation. It creates a safety net for the business and gives the business resources to continue to keep the ranch and the operation together rather than feeling forced to sell to the highest bidder and give up the history they've spent 100+ years building. Given all Sun Valley has done to minimize the impact to neighbors and the value that it brings to our community, I implore you to give Sun Valley and the Dominguez Ranch the chance to move forward with this project and build something we can all appreciate and be proud of. Thank you for your time and thoughtful consideration.
Okay, thank you. Now on to the applicant.
Thank you, Chair Farini. So appreciate the commentary and just want to emphasize, I did speak to Young and BZZ during the break. They want to be great neighbors. And again, we spent 6 months negotiating this, but it's been a moving goalpost. Every time we think we have a settlement, something's added or taken away that results in millions of dollars of future improvements. However, I did want to note that we went back during the break and we looked at the 1,500-foot setback. That would remove about 20 acres of the project that couldn't be pushed up north. So we also looked at other setbacks. We could potentially do 750 feet, and that would take out sections 1 and part of 2, but that acreage could be resited to the northern piece of the property. So that's where we've ended. We also think there could be some agreement where there was a condition that the full acreage could be planted until the time that the wine tasting is up and running. This application went in 2019, about a year after the cannabis application. And because it's a compatible use, it requires likely an EIR and of course a CUP with a hearing. So we think by the time, due to supply chain disruptions, by the time this winery is actually up and running, I think we're likely talking 4 to 5 years. So potentially an arrangement where there was a condition that nothing would be placed after the winery was up and running. We would essentially remove sections 1 and part of 2 to provide a 750-foot setback to the proposed Brouillard tasting room. So happy to answer any questions. We also have a map, if it was helpful, to show that in fact the project, as proposed, is limited to the 40 acres. We highlighted the sections because I know there was some confusion, but in fact the applicant, both in the business license and in the LUP, is limited to doing no more than 40 acres ever on the 70-acre disturbed site. And again, it's because of all the circulation roads along with the 100-foot setbacks imposed by the State Water Board, and also the big staging area, which includes, the parking, et cetera. So if it's helpful, maybe Mr. Villalobos can pull it up. If not, I'm happy to answer any questions.
Okay, Ms. Steinfeld, my pen did not write fast enough for the size of the land you would be giving up on parcels 1 and 2. What was that acreage again?
That's about 6 acres, and we would, again, request that we be permitted to plant 1 and that additional portion of 2 until the wine tasting room is operational.
Yeah, I think
After that point,
that's a great concept. I think that's really good.
Mr. Chair, staff has the picture up on the staff computer. If we can ask our CSBTV staff to broadcast that would be great. Thank you.
Yeah, and so the highlighted areas include areas where there will not be cannabis planted. And so that includes the setbacks, the internal roads. There's not just the setback from the larger ephemeral creek, there's also setbacks from other drainages. And then if you go all the way down to the bottom, that entire area also won't be planted, the staging area. So what we have left is a max of 40 acres. We've made that clear in the narrative project description on this map, and then also the business license. So under no circumstances will there ever be more than 40 acres of hoops on this site.
Commissioner Blau?
Yeah, my last concern is the roadway that we talked about earlier. I'm just a simple developer, but I've been stuck so many damn times on access and easements and roadways. I need some certainty that both your parcel and the winery parcel and any other parcel that accesses a public roadway from this non-public road is usable by all the parties that are there. So Ms. Seinfeld, I mean, ideally I would have a public title, or I would have a preliminary title report insurance me. I would have the ability to call my title officer and plot the easements for me, to plot the agreements, to tell me whether it's an offer of dedication to the county, so I know what it is. But right now, I don't know what it is, and I'm not very comfortable. And my concern is that although you're a very competent lawyer, I'm not sure how good a land planner you might be, and I'm concerned for the appellant because I'm quite certain they're not expertise in that area. So I got to have some confidence that this is not going to be some future problem for the winery and a future problem for you and a problem for the county.
Sure. And so I know the county dug into this. I'm happy to answer questions, but if Ms. Lair is available, perhaps she could start off and then I can jump in with additional information.
Sure. Commissioners, I may actually pass this along to Ms. Elkurdy, who is in control of what you see on your screen there. And if we can zoom in a little more, perhaps Ms. Elkurdy can walk us through kind of the vicinity area, and the yellow highlight is the access point from the 246, a portion of Drum Canyon, an existing easement to the site entrance. Ms. Elkurdy?
Yeah, so the access will be from 246 going up that section of Drum Canyon Road. And then when they hit this area, sorry, my cursor isn't showing up. Basically this kind of bottom corner where you see the C for Crawford, that is where they're going to be accessing the property. And from there, they are planning to just use the internal roads and not go farther up on Crawford Canyon Road. That's my understanding. And I believe it's kind of more in this upper area where they're are some concerns about washout. So that's the access that's planned for the property.
And so to ask the next question, has the county reviewed any agreements for the maintenance of that? I mean, the reality is, I'm guessing that in order for this operation to operate, the fire department has made a requirement for a 16-foot all-weather road. And I was certain that that's going to be the case for the winery or perhaps some other issue, but I'm not hearing anything that makes me real comfortable that this is not going to be some enormous problem in the future. So tell me how it's not going to be a problem.
Commissioner Blau, through the chair. So because this is a strictly outdoor cannabis grow, there are no structures, no habitable structures, no processing. Fire does not have any additional requirements for road width or maintenance for this project. As you indicated, if the winery goes forward, they will likely have to update some of the roads, and they will have to comply with whatever conditions that are presented from the fire department. However, I can't speak on that since I'm not familiar with that project. But as is, there is an easement from Drum Canyon Road that is essentially Crawford Canyon Road. As we understand it, the property owner, the Youngs, I believe, are currently maintaining that portion of the easement that they use to access their property. As you can see on the image before you, the access for the cultivation site is kind of on that lower, thank you, on that lower portion there, and none of the project vehicles, tractors, etc., will continue to use the easement alongside their property that I believe the Stranges were using. So there is an easement that exists for ingress and egress, and it is our understanding that the project applicant has the ability to use that easement for their site.
Okay, that's the answer to my question. I no longer have a concern. Obviously, if this is strictly a farming operation, they're not required to have roadways other than any that they want to create. I mean, they're going to have dirt paths, and that's how you get your tractor and your trailers down there. So as long as I know that there's an existing easement that they can use, and there's no requirement to have it maintained other than a farm road, then I'm not concerned about it.
And just one more thing to add to that. I would just like to add, if there is an agreement in the easement as far as maintenance goes, that's not something that the county would adjudicate or get involved in. That would be something to be handled between the private parties.
Except for the county has to have someone to maintain it if they require one. You're right. They would not be able to, for example, the winery, for example, if it goes in there, they'll be required to maintain and build the roadway. Whether they get someone to participate is of no concern to the county, so long as the county has a responsible party to maintain the road for the benefit of the winery. Am I correct?
Yes.
Okay, I'm good with it.
Commissioner Park.
A couple of quick questions for Ms. Steinfeld. If we could pull up that prior slide that showed the specific fields, point one, there you go. And you mentioned if there was a 750-foot setback, that would retire some of that grow. Can you tell us what the change would be on this map?
Sure, and I actually sent a map to Mr. Villalobos that shows the 750-foot setback. So let's open that up. Okay. And yeah, so there's this one, and so what this one shows is that The 750 line, the red dot is based on the 2019 plans that were submitted by the Hines family. And so it would take out, that yellow section was previously planted, but we pushed it up. So we could still get our 40 acres if we push them up to the northern part of the area. I also have another map that shows, it's a little bit more clear about which sections would be removed. And Mr. Villalobos, if you have that, that would be helpful. But essentially it's section 1 and a corner of section 2.
And then can you show us where the, what new part would be added in the north?
Yeah, so what we did there is under the existing project where we have only 40 acres of hoops, we have a lot of room and flexibility for circulation, for big rows between the hoops, big roads for tractors and other things, but we would compress the circulation areas. So these green areas just were bumped out a little bit to fill in some of the areas that weren't currently proposed to have hoops. So it would just sort of expand the existing footprint, but still staying within the historically tilled area, but with less room for circulation.
So wouldn't be making an incursion into some otherwise unplanted area?
Correct. And this entire 70 acres was fully studied and analyzed, and historically has been in hay or veggie crops.
And Ms. Macon referred to 12 acres in her presentation on rebuttal as being some alternative place. Is that the acreage you're talking about that you get from internal expansion, or is that something different? Or do you know what she's talking about?
Yeah, that's something different. So yeah, I can speak to that. And I was hoping we wouldn't get into the confidential settlement discussions, but now that it's out in the open, I suppose we can address it. But there's an area on the other side of the ranch that we had looked at, and we're considering whether we could move a few acres, but it would require at least another 3 years of CTS studies and water board studies. And with the cap, it's not a viable plan to reapply at this point. So.
And is that 12 acres currently cultivated?
No.
Does it have
it's
a history of
no, it's just a little more flat than most of kind of the hilly areas that you see on the majority of the ranch.
Right.
So it would be a full bio study, take permits. Fish and Wildlife would be very, very involved with that. It wouldn't perhaps be impossible, but I think we all know that cap will be filled very shortly.
Okay, I have no further questions right now.
Okay, thank you. Well, with that, we'll go ahead then and we'll close the public hearing and move on to Planning Commission discussion.
Chair Farini, if I can interject here, I'd like to provide a couple clarifications on some of the points that were discussed throughout today's earlier proceedings, if now is a good time.
Sure.
So just wanted to summarize a few things. The setbacks that Commissioner Park, I believe, had asked about in the beginning, there are 100-foot setbacks from the drainages. That is also a code requirement that all hoops are set back 100 feet from the edge of drainage. Just to clarify for the project description, the fenced area is about 70 acres, but that includes internal access roads, parking, storage area. The proposed cultivation acreage is limited to 40 acres. So to be clear, that's all in the project description. That is all they will get a business license for, and that is all they will be able to cultivate. The harvest per year are a total of up to 3 at about 4 weeks each maximum. For odor, because this is a land use permit, our code does not require an odor abatement plan, and it is not located in the San Ynez Valley Community Plan, so it's not beholden to those odor abatement requirements either. Regarding some of the ag policies that were brought up earlier, Just to provide some additional clarification, this project is subject to these agricultural policies and the agricultural element. The policies that I believe were of question earlier, I think we're just trying to clarify that, as Director Plowman had stated, these policies are for the continuation of agricultural use, which the project does. And I think the idea that we were trying to get across to the commission was that these policies are in place to protect ag from other types of uses. So it's not necessarily to use, comparing a broccoli farm to a cherimoya farm or anything like that. It's really the continuation of ag in the county and to protect it from the other uses and the potential conversion to non-agricultural uses. Lastly, I would just like to reiterate, this is a land use permit before the commission today, so the findings are limited to the land use permit findings included in the staff report. And I believe that that hits all the bullets I had. Thank you.
Thank you, Ms. Lair. Okay, on to Planning Commission discussion. Commissioner Park.
Is this really in my district, or did you just say it's there because you want me to take all the controversial projects?
I have my ways. Yes, it's your district.
Okay. I've been in plenty of trials where you got a case that you can't settle, and then after a day or two of trial, the handwriting's on the wall, and lo and behold, you're able to work out a deal. And this kind of reminds me of that. I don't know where the parties were even at 8 o'clock this morning, but they ought to see the handwriting on the wall, and they ought to be able to reach a deal. I want to give them a chance to reach a deal. I'll tell you why. One, I don't want to struggle with sorting out all the conditions of what might work with the 750-foot setback, et cetera, on the fly here. I'd rather let the parties do a professional job of doing it. But secondly, the advantage of a deal for both of them is you have closure, because if we come up with a decision today, then that's appealable, and then that can go up on a writ of mandamus and so on and so forth. Any intelligent settlement's going to get waiver of those things from all participating parties. So I think it benefits both sides if they're this close to actually reach a deal. So I'm all in favor of a very brief continuance so that the parties can achieve that. And I'll make a motion to do that after everybody else speaks.
Okay, I bet if you made a motion, you'd probably get a second now, but okay, go ahead, Commissioner Blau.
Yeah, as I've said it earlier, many times before, I'm very hesitant to not grant a continuance when a commissioner is just asked for them. However, this is what I'm going to have to say, that I can't support that. I've always agreed to do continuances when one or more of the commissioners needed more information, needed staff to provide some additional stuff, or we have to redo the findings. This is not the case. As I said earlier, they've got 10 days to come to an agreement where Ms. Steinfeld or the property owner could make some minor modifications to satisfy the adjoining neighbors. If not, they can appeal to the board. I'm not finding anything here that requires that, and I don't think we need to get into the posture of having appellants and applicants think that they can drag these things on forever and ever and ever to try and get some minor concessions. I think Ms. Steinfeld was very clear when she asked that this be decided today. This has been 3 years. That's enough. And if for some reason the appellant and the applicant can't work out whatever minor modifications in the next 10 days, so be it. Either the appellant learns to live with it, or puts up the $859, does the appeal, and goes through the process. And I'm quite certain that Ms. Steinfeld if what the applicant wanted was real minor in nature, is going to concede those, given the fact that it would delay the project by a month or two going forward. I just can't see where there's that much of a benefit to do the continuance. And quite frankly, my other fear is, okay, we continue for a week, and for whatever reason, the appellant's not happy with the negotiations that occur in the week, and they still appeal it. What have we done? So as far as I'm concerned, the conditions of approval, and I think Commissioner Farini was brilliant in pulling up the Google and convincing Ms. Seinfeld that, move get a 750-foot buffer. That sounds very reasonable. And I can't imagine what other concession might be made would make anybody happier. So as much as I hate not supporting Commissioner Parks' continuance, I can't support it. I think this project is where it needs to be. I can't imagine another concession that could occur that would make any difference. So I would hope that we could move to approve the project today with the modified conditions that Commissioner Farini suggested in the setback, and making a modification to where the 40 acres are.
And I think Commissioner Cooney left, but he left with his hand up.
Oh no, forever wanting to speak.
And maybe, I'm not sure if that was his vote for a second, or Commissioner Bradley.
I didn't raise my hand. I'm just enjoying the banter. I'm sorry.
It's your turn, though.
Oh, it's my turn. Okay. Okay. I feel conflicted about this because sending this case to final permit issuance, I think is sloppy. I don't like the graphics on the plans. The discussion about the 40 acres being within the 70 acre and the grow area, I guess I could live with that. It's really, really important to these appellants. And so it concerns me. And so I kind of side with Commissioner Park in trying to continue it and work out a couple of those details. I'm not necessarily certain that it's going to come to a resolution of the parties. But the document that we're kind of finishing is a little, I can just imagine in 2 or 3 years, someone's going to pick up the file and wonder, where was that 40 acres supposed to be? Could it be here or could it be there? I guess it's anywhere within that 70 acre swath. But I would support Commissioner Park in the continuance. That would be my vote today.
Okay, thank you. This really gets me with Commissioner Cooney's hand still up.
These are tie vote.
Mr. Wilson.
Kind of like El Cid, isn't it?
A little bit.
So Commissioner Park and I do this dance almost every hearing, so we're getting pretty good at it. So he set it up for me. So thank you, Commissioner Park. Depending on the motion and where the commission wants to go, I just want to provide potential dates if the commission chooses to continue it. June 9th is our next hearing, which is next week. I don't know if the parties will have enough time to provide updated figures in that time. The next hearing after that is June 30th. So I think my recommendation is to continue it to June 30th. And that's the information I just wanted to add.
Okay.
I have one more question if you're going to do that. And that is, are you doing a meets and bounds description? Tanner, quiet. Are we doing a meets and bounds description on the 40 acres that's going to be cultivated? Or are we talking about 40 acres within the 70 acre parcel? Because it seems to me, if we need to get that specific, it's starting to get a little ridiculous. I mean, do I need a surveyor now to go out there and tell me where my planning's going to be? I mean, Commissioner Farini, when you plant your 100 acres of strawberries, are you getting corner stakes from the surveyor to tell you where the 100 acres are, or is it, take a tape measure and go from here and go from there? And
it's all GPS sub-inch accuracy now. So you're asking the wrong guy. Yeah, everything's down to the point, right? But I agree with you. I mean, if we get the 750 feet, stay 750 feet away from the winery when it's in, that's really all we probably need. And if they float things around because they need to, or a hoop house didn't fit, I agree with that. We don't want.
And I gotta say, although yours may be all GPS because that's how your grader operates, that's not all farmers. I mean, I got a lot of the farmers that I deal with, and they use tape measures from the street corners. I mean, if that, or as opposed to, it's a runabout here someplace,
All right, Director Plowman.
Thank you, Mr. Chair. I just wanted to make sure Commissioner Bridley had a good understanding of where that 40 acres was, because I think it was a bit confusing in the presentation. And subsequent to our lunch break, we really sorted out that the graphic that staff put up that showed the red areas, that's the 40 acres. And it looks very deceiving on that site plan because there's a lot of thin slivers of land on a very long parcel that make up the other 30 acres. So all of those boxes that were on the site plan total 40 acres.
Yeah, because I thought I saw an exhibit where the additive acreages came up to 70. Maybe there were additional ones beyond those red that.
No, so the red areas total 40 acres. The fenced property total 70 acres.
Okay.
And it looks very deceiving because the red areas look so large, but there's enough land in the staging area and in the roads in between the grows and along the edges where the setbacks are, that essentially comes up with 30 acres.
Okay, so
perhaps Ms. CSB TV can pull up the presentation for the commissioners here and show. There we go.
Okay, that would change my vote, really, because I mean, what I'm trying to do, and also I really appreciate Ms. Steinfeld's suggestion about a couple of tweaks in the project description that they're willing to do today. That's kind of making it a little bit better for us. Right. Okay,
There
so
you go. That's it.
Go ahead.
That's the graphic. So everything in red totals 40 acres.
Okay. And so that is any one of those points is where the 750 feet is being measured from, right?
So if the first, down, let's just say the southwestern corner where the staging area is, that first block would be removed once the winery was operational, and a little corner of the second block would be removed. And that acreage would be shifted toward the north, and they would shrink the internal roads to accommodate it.
Okay. Okay, so that would change what I want to do today. I mean, with that understanding, I guess I'm just a little bit nervous that, we'd actually have to have staff come back with some sort of fix, because I guess we just don't do minute motions that let you fix it in the record without us looking back at it. But
yeah,
anyway, that would make a big difference to me because it was confusing, from start to finish. I really appreciate the clarification. Right. And I apologize for that switch, Commissioner Park, but that's kind of how I'm thinking.
And Mr. Chair, we would need, excuse me, Ms. Strange. Mr. Chair, we would need, 10 minutes plus, 10 to 15 minutes to modify the project description to accommodate that change by Ms. Steinfeld regarding the setback for the winery once it's operational.
Okay. Thank you, Director Plowman. Yeah, and Ms. Strange, I'm sorry, we've closed the public comment, and now it's just between the commissioners and staff. So no further comment. Okay, so Commissioner Park, I will go along with you on this. I'm kind of with the other commissioners, though, that I think we've done a pretty good job. I like what the applicant did to solve the winery issue, and that was the big one in my mind. I think the road thing, I understand it better now, but what are your other concerns on why we should continue, Commissioner Park?
One, I'd like to see this in better form, and I don't want to waste 15 minutes. It's going to go to half an hour to fiddle with the project description today. When you've got a project that's taken 3 years and it's not going to start planting cannabis for another year, and it can't wait a week or 2 or 3. I'm greedy. I want to solve it all. And I think that the Strange family probably sees what I call the proverbial handwriting on the wall and would probably like to negotiate something on the hoops. And they ought to have an opportunity to do that in private with the applicant to see if the Stranges could be satisfied, because then you could settle with all the parties instead of just one. And because otherwise you won't have a settlement. Everybody will free to appeal it. I also am very strongly in favor of the changes in the landscaping plan that I proposed, because I think that if you plant oleander and the cypress, you're going to potentially cause damage to both the cannabis crop and to the biological resources, and that needs to be changed. So I think if the parties take a little bit of time and do it on their own and get it right, they'll have a better outcome. So I'm still going to make the motion to continue the matter. And if we have to vote today, I won't vote for the matter. Okay, so I will vote to continue this matter to, I'm going to propose June 30, because I think the parties, there needs to be some technical work done to clean up the graphics. And I think you'll be pressed to do all that in a week. If somebody can convince me you can do it all and have your negotiations done by the 9th, I'm fine with the 9th, but I think you probably need till the 30th.
Okay, Commissioner Park, I will second your motion for continuance to the 30th. I'm not sure if staff needs any further input from the commission, or do you think?
So Chair Farini, just to summarize, the motion includes working with the applicant to update the project to include a 750-foot setback and relocation of the cultivation area towards the northern portion of the 70-acre fenced area, as well as Commissioner Park's suggested changes to the landscaping, which includes the removal of oleander and cypress with some other native plants, including but not limited to potentially coffeeberry, hollyleaf, Catalina, ironwood, and some of the other ones that were listed. Do I have that all?
I believe removal of the cypress and the oleander. Did you say that already?
Yeah.
Okay, yes. Thank you.
And such other items as the parties agree to, and they may agree to
Sure.
something else more comprehensive, for example, on the extent of the hoops, and that might result in a waiver of appeal rights.
Okay.
That certainly doesn't make extra work for staff.
Okay. Commissioner Bridley, Commissioner Blau, your hands are up.
Just waiting to vote.
Okay.
Okay.
Mr. Wilson?
Chair Freeney and commissioners, just before the vote, just want to lay a little framework. And we're looking into one aspect of it. Being that there's only 4 commissioners present at the moment, even though Commissioner Cooney has his hand up continuously. If the motion ends up with a 2-2 vote, then the motion fails. And we're looking on if there's any other ramifications. Typically, if a motion is on a 2-2 vote on a project, then it's deemed denial. If it's a 2-2 vote, it means the motion fails and then a new motion can be entered. In the absence of a new motion, then we're looking into whether the motion on continuance would also be considered a deemed denial. So that's where we're at currently in regards to the motion. So we can proceed with the vote if you would like, and then we can see how it falls out, and then we can provide further instruction afterwards.
Well, Commissioner Bradley,
Yeah, wait, let me make sure I understand this. Secretary Wilson, you're saying if it's a 2-2 vote on this, it would be possibly considered a denial of the LUP, of the appeal, or just denial of the continuance motion?
So that we're looking into that aspect of it. But if it's a 2-2 vote on the motion, then that motion will fail, and then a new motion can be entered. What we're looking at right now is if it's a 2-2 vote on a continuance, if that also means the project and the appeal is all deemed denied today.
If I could weigh in here, just if we vote on the continuance and it's 2-2 vote, then the continuance doesn't get granted. I'm going to make a motion to approve the project, subject to the conditions that Commissioner Park wanted for landscape differences and Commissioner Farini's 750-foot setback. Now, if that motion were to fail, then the project would be deemed approved, I think, because it reverts back to the LUP director, because the denial the appeal was not approved. If I'm wrong about that, let me know, because it might change the way I vote.
Ms. Richardson.
Chair Blau and the rest of the commission. So as Mr. Wilson was saying, we were checking the procedures, and if there's a motion to continue and there's a tie vote, if there's no follow-up motions, that would be deemed a denial. And how we treat deemed denials for appeals like this, it would be a denial of the LUP. So it's not just a denial of the appeal, it would be a denial of the permit. And that action would stand and could be appealed to the board, but it would not revert back to the director's decision.
So if someone makes an appeal, you're telling me, and the appeal is not affirmed by the commission, the appeal is considered approved? That makes no sense to me.
That's how we treat it. The language is not a model of clarity, but it discusses that it would be deemed a denial. And we've treated that in the past as a deemed denial of the permit.
Can you repeat that for like a simpleton? I'm totally confused now. I understand the continuance of the item today. That's simple, but then the denial of the permit. Do it again, please.
So if there is a motion, so motions of the commission to pass need to be approved by a majority of the commission. If we reach a 2-2 vote, that's failure to achieve a majority, so that motion would fail to pass. The Planning Commission procedures say if we reach that point and there's no follow-up other motions for some sort of alternate action, then the motion's failure to pass is deemed a denial of we treat that as a denial of the project.
Except that if we make a motion to do the continuance and it fails, and I make a subsequent motion for approval of the project and it's approved, the project goes forward. Am I correct?
That's correct, Commissioner Blau.
Okay, so I have a question here for Commissioner Farini. I would vote for the continuance if I thought you were going to vote to deny the project. If you're not going to vote to deny the project after continuance is not appealed, then I don't want the project denied, because that would be ridiculous. There's no merit in this project being denied. I abhor the idea of making the applicant wait another 3 weeks and spending, give me a guess here, Mr. Wilson, you're good with the accounting for these kind of projects, another what, $2,000-3,000 to the applicant for additional county staff fees and commission hearing times and so forth. For what? I don't get it.
All right, I've got an answer. So what I would like to see is these guys are going to be neighbors for a long time. And if we ask them to take another 3 weeks and it can make a little bit better neighbors for the long term, I think it's worth it. I'd like to see us just kind of come together. It's Commissioner Park's district. We're a little bit separated on it. I just don't think it's a hill to die on. Let's continue this thing, and we'll come back on the 30th. If you gave it to the applicant today and they move forward and got everything done, got everything rewritten, their next step is the CEO's office to get their licensing there, and then they got to go up to the state, and they're going to miss the planting window anyway. So, and the applicant has a lot of certainty right now that they're going to have a project. We just want to cool our jets a little bit. If we could just cool everybody down, I'd appreciate it. I really appreciate the votes. Okay.
I'm not getting excited about it.
Yeah.
I know I'm supposed to not say this, but Commissioner Park and Commissioner Free owe me one. It may be lunch, but
Okay.
you owe me one in this one.
All right.
Is that fair enough?
You're on.
All right. So based on that, Commissioner Park, I will support your continuance. Although, can I talk you into a week and not 3 weeks?
No, because the staff needs.
I think staff needs the time. Mr. Wilson has requested us move it to the 30th.
Really, is he going to do the drawings or is the applicant going to do them? Mr. Wilson, tell me if you can get it done in a week as opposed to 3 weeks. If you tell me you can't, I'll support it.
Well, Mr. Chair, maybe we should ask the applicant if that's a product that would help.
Commissioner Bradley, let's just see if Mr. Wilson says they can do it in a week. If they had everything done, can you write it up that fast? Get the graphics, change the plans.
Let's say they haven't heard what the settlement is yet from the parties. They need a little bit of time.
Okay.
Well,
Ms. Richardson, your hand's up, but
I'm not on the commission, so
I'll weigh in.
it needs to be the 30th of June in order to do it right.
All right, so I'm not going to argue. 30th of June is fine.
Mr. Villalobos, roll call, please.
Commissioner
Moved
Bradley.
Aye.
Commissioner Park.
Aye.
Commissioner Blau.
El Cid.
Chair Farini.
Aye.
Motion passes 4-0.
Okay. Thank you. Mr. Wilson, are we deemed complete?
Chair Farini and Commissioners, yes, we are now complete for this day.
Okay. Director Plowman, thanks for sticking with us today. I think your ability to help us through some of these issues it was really helpful to me. So I appreciate it.
Happy to be available. I know these cannabis cases are complex, so I
Yes,
try to
yes,
turn them
they are.
around.
Yes.
Chair
Okay.
Farini, can I say one more thing?
Yes, sir.
I think we also need to praise our clerk, David Villalobos, because this whole COVID shutdown and how we handle things has been crazy. And I think that Commissioner Briley did a wonderful job as chair last year under such bizarre circumstances. And every one of these hearings I go to, and I watch Mr. Villalobos juggling all the parties and being polite to everyone and getting them to kind of speak at the right times. It's just a gosh darn miracle, and I really appreciate it. So thank you, Mr. Villalobos.
Totally second that.
That's very sweet of
Mr.
you.
Villalobos is a rock star.
I have one more question, if I could, for Mr. Park.
I think he left the room. Oh, no, there he is. Okay. Go ahead, Dan. I'm sorry.
Sorry. When do you think we'll hear on the appeal on the earlier court case on Busy Bee? I'll tell you what, that really, for me, reading that and reading that judge's analysis of the case and his decision was fascinating, and it would be, I think, so helpful going forward as to how we make decisions on future cannabis projects. And it looks like we've got at least 2 years worth of them, would you say? I mean, we're going to continue to hear appeals and hear different projects going forward. So I'm just curious when that appeal might be certified so that we can use it. And I'm curious to know what your thoughts are on what the judge had to conclude.
There's 60 days after the judgment becomes final for the any party to lodge a notice of appeal. And I don't even know if it's a final judgment yet or not. And then after that notice of appeal is filed, it typically takes about a year for an appeal to be heard, plus or minus. And so we're a ways off before we go to an appellate court and we hear from what the appellate court says. That being said, we should take into account the fact that all of these writ of mandate cases wind up in front of Judge Anderle. And Judge Anderle has, he knows his own mind, let's put it that way. I love him as a judge and I love him as a person, and he knows his own mind. So he's not likely to change his mind on how to handle these cases. And you'll see a consistent treatment by him. And he's well respected by the courts of appeal. But you won't see an appellate decision that is binding on other trial judges until a fair amount of time. Hope that answers your question.
That sounds like everything we go forward and do in the future will be along the lines of his decision. Is that what you're saying?
I'm getting a warning that we shouldn't be talking about.
Oh, is that right? Oh, I'm sorry. I thought we were done with the meeting.
Yeah, well, I am a beer.
Okay,
I'll hear.
Bye-bye.
We'll see you next time. Bye.
Bye-bye.